have you communicated with a social media user who goes by the name ThATuMBRELLAgUY?
I've had several phone calls with a person who goes by the name ThATuMBRELLAgUY. Don't actually know his real name.
And unfortunately, every time I make a call, it becomes content for an idiot.
Help! I've been tossed overboard.
I'll have to bill you extra for my time.
Welcome to the show. You look incredible, like a dessert that owns a yacht.
That's exactly the vibe I was going for. You know, sweet but slightly out of your tax bracket.
Mission accomplished. How does one even shop for a suit when your head is...
Gold on my neck, gold on my hand, purple with the stripes, that's the walk of a man. Sidewalk shining, city lights humming, every step I take, they know a boss is
blazing the whip, gotta vanquish the needs. My kingdom for some poppy seeds, yo.
Is that a poppy seed? You realize I'm your P.O., right? Straight to booking!
Was barking on the phone, all that tough talk threatened. Now you looking at the floor like judge, I'm just stressing.
Police or zombie problems? Your tortoise won't stop breakdancing?
Try blue tape.
The miracle of our age. Yay!
Hey, we love that umbrella guy. All right. Thank you.
I'm calling from Los Angeles, and I'm having a little problem under the name ThATuMBRELLAgUY. I sent him my phone number at least 20 times in the chat and told him to call me. He ignored me, or I'm a man. I filed the report. If you guys could take a look at it and give me a call back, I would love to hear what you guys can do to help us. We really need to kind of stop this guy at least until Monday. I told him to call me, or I'm a man.
You know what? I talked to your mayor.
Yo, 100K gone. You thought it stayed quiet, huh? 2G in the chat like. Yeah. You flash fake racks on the timeline. Captain said check me, did with grind time. 100 bands raised, 100 bands off. You the touch to the halo with a cross. 56K from an angel in the comments. Heart full of faith, you turned to the prophet. Screenshot saved, every promise, every pledge. Bank statement singing when you tweeting off the edge. You ain't built for the smoke, you invited. Try to play God, now the numbers indicted. Seems like razors cut through the myth. Whole squad looking like an organized grift. 56K from a donut thief. 100K gone, a stolen dream. Gotta stay dark, but the neck got teeth. Make you mean, and you clip, and you caught on stream. That umbrella guy call it out on screen. Yeah, we see you, we see you. You prayed on the pain, turned trauma to a token. Each side story just a tool you were holding. Help the cause, every line pre-written, but the cause was your closet in the car you sitting in. You love weak links, hunt them in the thread. Baby, I care while you strip their bread. 56K from one, that's a life in ash. Your bar drip, that by time they'll never get back. That means get your face with a clown crown clips on repeat when the lies all fall down. To a G on the mic, every chart, every slide broke down a breakdown, let the numbers collide. You can't hide from the playback, you can't scrub with the chat track. Every blast you turn back and every trust Trust me now, backfire.
You ain't a boss, you a bookmark. Held on the page where the fraud start. Whole damn mark in a thread in the chart. History written in the sidebar remarks.
56K from a donor thief. 100K gone, that's a stolen dream. Better stay dark, but the net got teeth. Now you mean, now you clip, now you caught on stream. 56K from a donor thief. 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 Run that map, 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 run that map.
What's up, Bows? Welcome to a holiday weekend edition of False Flaggers Flagging Everything. I wonder if we, for some reason, go down today. We will be back, by the way. There have been some, either YouTube is being glitchy or who knows? Who actually knows? But interestingly, somebody false flagged last night. They weren't happy about what we, now we got it back, of course. It's setting on private now. That's what happens. You get a takedown and then it comes back. So it's, it wasn't a privacy complaint, by the way. It was just some whiny fools up here. I'm wondering who. I mean, really. Oh, I bet you they really tried hard to take down that interview too. I bet you they worked really hard on that. But still, it's still up there and still looking beautiful. How you folks doing, by the way? I hope you had an excellent 4th of July. The little ones and I went out. We, oh, Lord, everybody around here, they were going to town last night, man. It was pretty wild. I'm always shocked every year when a lot of trees don't burn down. Considering some of the things people fire off. I did see somebody fire one of those gigantic ammunition shells. The ones that are like show quality. They have like gigantic reverb, and it hit a tree. So I'm actually surprised with it being as dry as it is and everything. I was like, oh my Lord, they're going to burn down some trees over here. But it was still funny. It was funny to watch them. It's always funny to watch the stupid. The girls had fun though. We did get some ammunition boxes, stuff like that. Stuff that's well, it works for them. The little one got a firework backpack packet from Black Cat. They have like a little kid setup, but it comes in one of those clear backpacks, and she liked that. She always likes 4th of July until like she gets a little spark on her hand, like a few sparks will touch her or something, and she's like, I've been burned. You'd think she's been maimed or something. I've been burned, Father. She cracks me up. But they had a good time. We were out for about an hour and a half or so doing that. But it's really funny. She is so dramatic. The little one is. I mean, they're both dramatic, but man, the little one is very dramatic. Yeah, she's just playing with a giant sparkler. The sparkler's as tall as she is, and she got tapped by a couple of sparks. Oh Lord. She was like, I'm done. She went from, yes, we have to have fireworks. It's the best thing ever, to I'm out of here. I'm done. Today we have a really big filing. It is a BBB filing, which it's a anti-BBB filing. I'm going to say BBB. Let me pull this up. It's not filed by BBB. It's about his appearance, and it's essentially answering the questions of, hey, BBB. He keeps saying that he deserves X, Y, and Z, and this is Hale's answer to it. Now, remember, BBB has brought in some, I'm going to call them some heavyweights to try to, he knows he's in trouble. He's got a real problem that he spun off of the thumbnail case, which is It's kind of surprising, all things considered, because BBB, he, well, let's just say he was in a pretty good position with that. You know, there was no liability for him at first. You know, he had Scott Stark that was attached to that case. So Scott Stark's estate would have been partially liable for what happened with the thumbnail case, and also Michelle Preston. But BBB was not liable for anything. But remember, BBB could not stay out of it. He had to get involved. He got involved behind the scenes, and now he does have a problem, and it could potentially be a very big problem. We'll have to see where that goes, you know. But this is pretty good. You also had last night, interestingly, you had some threads popping off. Yeah, I totally forgot to put up I put up the live stream, I think within, 10 minutes of the show, 15 minutes. So numbers are getting in here. My Lord. Let people know we are live. I didn't know if we'd go live or not. I had to see what happened with the other one real quick and how fast we recovered it. We recovered it pretty good. Last night also, you had some threats popping off. Check this out. You had a few John Cook statements that were popping up that were, well, let's just say they weren't the most pleasant things in the world. Here you go. Check this out here. Here's John Cook talking about, these, again, when you put everything together that has happened over the last few days, what you get is, between him and between Lynette Preston, you get what very much can be construed as just out and out threats. Out and out threats. You have John Cook talking about how Ashley's going to regret what she did. I will make sure of that. Now, this is a guy that talked about feeding people to alligators and other horrendous things. So when he's making statements like that, again, it would be very easy to construe what he says as a threat. And not just, when I say to construe it, I'm not just talking about like you or I looking at it. I'm talking about potentially, a court or law enforcement. Because again, this is a guy that has gone on, he's said some pretty awful things. So when you're talking about, again, feeding other people to alligators and things like that, yeah, that's a problem. That's a real problem there. And last night, again, he was making pretty abundant threats. He was making them over in the old 2L sphere. While they did a bit of damage control, apparently. There were some posts about that I saw, which it's interesting to see them try to run with all of that. Oh my Lord. Yeah, they've been trying to push that whole idea that there was pay that went on. Even the 2L is now trying to walk back the statements of saying that is an absolute. Oh, you want to see something really funny that happened last night too, before I forget about it? Man, let me pull this up. This is actually really funny. So, it shows you there was a demonstration of the whole Vetcher shit and how terrible it actually is. So last night, look at this. This is really funny. I got a good kick out of this when I saw it come up. Hey, thank you, by the way, Grace. I hope you had a great holiday. We did. I hope everybody else did. Yes, indeed. Indeed. And Simply Me, Connie, what's up, Simply Me? How you doing? Taking heat off of them and Fleesa, trying to put it on Ashley. Yeah. It's them trying to flip the script, as it were, to blame somebody else. And meanwhile, check this out. This actually is pretty funny, the way that this plays out. So last night you had somebody in their chat. There's screenshots of all of this. By Nikki is putting these up together. Originally, Allison catches all of this, and then somebody went through and additionally circled everything so it would be easy to find here. But you see, last night somebody decided to troll 2L, and well, the 2Ls. They're actually the 2Ls were on, and decided to tell them that their former co-host Tammy J had said, "You better send her wallet." That's what she said. So this person convinced them that Tammy J was sitting around online, again, their former co-host, saying, you better send them a wallet that they were supposed to get. Apparently, that has become kind of interesting because there was a wallet that was ordered by one of the let's just say one of the bigger donors out there, and that item apparently never made it to who it was supposed to go to, with Tammy J. Now, that's not good, right? But Tammy J actually didn't say anything about it at all. Tammy J is pretty calm about things. But this comment right here sets off an implosion, which is really funny because later on, the person notes, hey, that wasn't real at all. It was actually trolling. Look here. I'm joking, Tori. I knew that would set you off. So they go in this big rant about, that Tammy J. Oh, it's so funny, guys. People are just having at them in their comments, having a good time with them. And they go further than this, pointing it out. They're like, again, they're sitting there, they're having a freak out about it, which, like I said, is pretty funny because they show that they don't fact check this stuff. They just assumed what what this random person in chat told them, and this has been a real problem for them for a while now. Just believing random people and random comments in the chat. Now this person comes back and tells them, people are like, it's funny because you can see it even in the comments. A bunch of these people, they don't catch this at first, right? They don't notice that. You can see some of them here. They're like, oh man, Tori, I want something get swamped. I give it to Tammy, and now she did this. She can F off. I like how they can't spell. I'm ungrateful piece of it. So it sounds like they're an ungrateful piece of, but they're trying to say that she is an ungrateful piece of, and it's all fake. None of it's real. So, and this person, the funny thing about it is they let it be known that that the reason they even know about this whole quandary, the whole mess, isn't because of Tammy J. It's actually because 2L had told them the other night that there was this thing with a wallet. Again, yet another product that apparently didn't arrive with somebody. I personally, I don't know if I'd want a wallet from some of these folks. Now with many pings, but what do I know? I did think that was really funny though, because it doesn't just point out again the whole idea that the whole bet your shit thing doesn't happen. But one person can, really sidetrack their entire thing that they're trying to do. Oh, that cracked me up, though, when I saw that. I thought that was really funny. There was another thing, too. Let me pull up, where they were going after. Again, they decided... It's essentially been between that and attacking the bench donor. Apparently the bench donor is yet again under attack. Oh, and there is something I was very I guess intrigued by, so LP put up something. Let me see. Let me find it real quick. It was a pretty innocuous post, but some people pointed out something that was, I don't know, kind of interesting. Oh, wow, she's been posting again today. Oh, man. So she posted last night about fireworks. And remember, she posted not too long ago that the little one is autistic and cannot stand loud noises, right? So she posted about that and said that I thought they were awesome. The little one at first was terrified. I know it's not on the screen. I'm going to pull up something else in a second, though. She doesn't like loud noises, so that was very hard. But when she got used to it, she thought they were pretty. He was like, wait a minute. So, there's a difference in if someone doesn't like something, and if you're saying they have a condition where they can't stand something, there's a big difference. There's a big difference there. And what's funny is this gets framed in a different way because somebody points this out, and instead of actually addressing that, it becomes about my stalker. This comes up 2 hours ago. Oh, dear Carol. Oh, dear Carol. Dear Carol. There's no protecting order against John and I on or by our stalker or anyone else. The order ended April 20th, and there has not been another one reinstated, and I can go anywhere I'd like to go. I'm not going to stay away from fireworks in my near area because of a stalker. Here's the thing, first of all. I don't feel like it. I don't feel like this is a hard thing to understand. If you actually felt you had a stalker, yeah, it would limit what you do. I've had an issue before, let's just say, where I absolutely felt that we had issues, and I would not go any place that I thought that somebody could pop up. So to claim, hey, I've got this stalker that's doing X, Y, or Z, you must not really feel that way, because your actions. If you think you're in danger, people who think they're in danger do not do things. I'm just saying, and they should. I mean, they've been going to flea markets and doing all kinds of things forever. So it's not like, Hale. Hale's very rarely even talked about these folks lately. So, but this is what I'm talking about every single day, day in, day out. They have Muppets for their pictures. Muppets! Muppets for their pictures. You're posting publicly, man. People are allowed to comment on your public posts. That's how it works. People actually photograph the public posts, by the way. They don't comment directly most of the time because you don't leave your comments open. So they don't even comment directly to you, but they absolutely have the right to comment. See, it's strange because they commented about when Ashley did an interview, they commented about Ashley's interview, right? And they have every right to. They do, regardless of if I think they're full of shit or whatever. It's public, right? So just absolutely ridiculous. They have no idea what they're talking about. But hurt people. That's all I know. All I say, I pray for. I wonder if there's any more comments. I'm surprised there's not like 5 more comments. I didn't even notice that until just now. But yeah, they've been doing their best to. I don't think they know how to handle the Ashley discussions right now over in that mess because yeah, there's a lot of stuff that goes with it. If people start looking into it, it doesn't look very good there. But anyway, I thought that was interesting as well. Oh man, something to bark about. I'm glad you're right here. Let me check your channel real fast, okay? I need to see where you're at. I'm glad to see you. 1 second, people. Something to bark about. So something to bark about is 29 subscribers off of 1,000. If LP can get 1,000, this damn channel can get 1,000, man. So what I'm going to do is I'm going to link it while we're talking. I'm going to put it at the top of the chat. It is free to go and to subscribe to. So it doesn't hurt you in any way, shape, or form. Just hit that button. Get them to 1,000 so they can begin their monetization process. Give me 1 second. I'm going to post it there. 1 second there. There it is. All right. Here we go. Heck yeah. I'm pinning it to the top. Now, if you do me a favor, folks, again, if you have not subscribed to Something to Bark About, their channel is at 980 now. So look at that. We have 20 more. Well, we have gone down from 29 to 20. All they need is 20. And that's it. Again, if LP can get 1,000, this channel can get 1,000. Come on. I think that would be beautiful. It's also a beautiful remark on they haven't really done anything, like, oh man, you need one more now. Something to bark about. You go into that 1K place. It's about to, it just happened. Bam. Look at that. Boom. I love it. I love it. Okay. So today, on top of that, again, man, 12, almost 1,300 of you have already made it here. I appreciate you folks. Again, holidays. I apologize for last night's video. Last night. So apparently what happened, I'm trying to get all the detail to it because it couldn't have taken very long with it to get it overturned. But apparently somebody false flagged last night's video. I can only guess who. I have a very limited audience guess. You know what I mean? It's a very limited one, but I can guess. Now, the only thing that sucks about that is every now and then, some of the live streams, YouTube is so finicky about this. But some of them stay ad relevant, some don't. And for some reason, even though there were some horrible words said by John Cook, and we actually pulled those up and talked about all of those statements last night, where he was taking aim at Ashley, threatening her, saying horrible things, and going after her husband and oh man, her husband. He's one of us for sure. His answers, they were amazing. They were absolutely amazing. But yeah, even though that came up, it still was monetized. So they interrupt they effectively kill the video when they do that. That is the only downside to those. And if I unprivated it, so what happens is it takes it down, and then when you get it back, of course you have it it'll either come back unlisted or you can private it, and we private. But when you do that, it takes it right out of their algorithm, so it effectively kills a video, and they do that every now and then. They manage one, but they haven't managed one for any amount of time in quite some. It's a broken system out there, but the getting them back like that also shows you that these people are they're false flaggers for sure. Absolutely. But that is that is what happened to last night's video. Now, do you want me to read you a wonderful exchange with Lynette Preston? Would you like to hear some wonderful stuff there? you know? Give me 1 second. I gotta find it real quick. Give me 1 second. I'm looking for the messages here. Man, okay. Would you like to hear some wonderful exchanges? I have a few. Now I'll have to read them to you because I don't have them screenshot. But this is some LP exchange. She writes people with the shame on you. I kind of love how like she writes and tries to attack. So here's her writing. Shame on you, Sammy. You know I never played a hand. It's supposed to be laid a hand on her. I always told her how beautiful she was. And isolation, really. We went to every horse, failed goat sale, cow, pig sale, every kind of thing you could think of. We did camping, fishing. Right. She was isolated, nothing but lies. I pity her, and I pity her husband with all the lies they're spewing, and you too. I don't know why you would do this. God pays you back, honey. I wouldn't want to be in your shoes or hers. Yet again, God pays you back. Don't you love that stuff? And then she got to ask, hey, why would John post something about, her family? This is ridiculous. The answer with that stuff is real, Sam, I have no idea. I'm not married to John. I'm not always with John, so I can't control John. John is very upset. What Ashley did by going on Tug, lying, so lying is ridiculous. She calls the police on me for sending her an email asking her to remove 3 videos, and then goes on a show and lies through her teeth. What a piece of crap. It knows it's lies. Oh man. She's really butthurt about her appearing on the show. You can very well tell that here. Give me a minute here. Good Lord. Let's see. I didn't steal Debbie's husband. Debbie stole mine. Got pregnant doing it. We had a baby a month apart. Your mother has stalked me for 35 years, and I'm over it, and I'm going to do something about it. Believe me, I'm going to do something about it. I don't want any of this, but I'm going to stick up for myself and defend myself. I wish to God that we could make up and just be a damn family. But I can see that's never going to happen, and it breaks my heart. I'm so sorry for the lessons you have to learn. Wait, what? Is that what that said? Oh my God. She's so crazy. Good Lord. For the lessons you've had there. I'm sorry for the heartache you had. And again, I told you I was sorry for the horrible thing I said to you, but I still love you. I'm still your mom. Always be your mom, even though I'm threatening you. That's lovely. In my heart, no one else can take those memories from me. Ashley, contain them and lie. Her jealousy is ridiculous. She's jealous that I adopted a child. That is the saddest thing on earth. And she asked me to name her Annabelle, and I said no. And I guess I heard her made her mad. I don't know why she is doing this, but it happened when I adopted HG, and that's all I got to say. And I don't control John, but he's going to keep going. I guess he's defending me, and he will keep going. He probably will keep going as long as people are lying about me and doing what he's. See, this is her separation tactic. It's not me. I'm not doing it. I'm not the one actually making these horrible threats. Okay. You know? And he'll probably continue, and I will do it legally. I can't control him. I'm telling you, man, you bite off that. First of all, like I said, she gave us carte blanche to talk about anything. Because, again, you lying about contacting me in public is one thing, but baby, when you try that in court, oh fucking A, I am going to wreck you with that. You like, help me put this person in jail. Well, I mean, you're back with them. That makes it sound scammy, doesn't it? Doesn't that? And then she was told, I'm not your daughter. I have a mom. I believe Ashley. I have no reason to. Soon enough, with all the records of her visits, therapy, and other court documents, guess we'll see. You know? Well, it's crazy, too. They tried to weaponize the idea that a person that was in that has been put into a terrible situation, that they would want to come back. Have you ever heard of the term coercive control? Have you ever seen what abusive people do? Have you ever seen how they control other people? Because once you really see it or experience it, you know, people that, especially if you get it, if you have somebody that gets their hooks into a child, children do anything to please somebody. That's crazy. So she ends up getting blocked at the end of that. But yeah, she decided that she thought it would be fun to start that old smack. What's funny is I'm waiting for her to motivate someone like Ashley to fire up ye old YouTube. And, you know, when she wants to talk about something, you know, videos could be about her and her chickens or whatever, you know, whatever they have part of the time. And if she motivates her to talk about LP, I mean, hey, all you need on there, by the way, Ashley, for monetization purposes, all you need are two things. You need 1,000 subscribers and 4,000 watch hours. 4,000 watch hours may sound like a lot, but you would have already more than had that just with old video. Now, your old videos won't count toward a new number, but man, a couple of videos with decent numbers on them. Again, you put out, so say you put out 2 hours of content, and those 2 hours of content, they get 8,000 total views. You know, you're talking about live stream. There you go. That's half of your stuff. So you'd very easily hit it. You got it with live streams before. You know, you could very easily have that. And I actually think it would be funny. Again, you do in your life whatever you want, but I think it would be so funny. These people are so horrified by the idea that Ashley and her family, that they're going to have success. And my Lord, I love that they're not taking shit from these people. And I kind of love it. I love that the family is, you know, you've got people that are backing Ashley too, and they're like, "Yo, like, why wouldn't I believe her on this?" So anyway, I thought I'd read that to you. Now Jason's very much. I think he could. I liked his post. Like I said, his posts were funny. I like the fact that they stand up for each other. You know, with I mean, John's out there again. John's making threats. He's straight up making threats, and some of the statements that he made yesterday, going through all of them. I mean, he wasn't saying things. Look, he's not disputing things with them. She talks about action, by the way. The things that he said about all of them, you know, it's the standard stuff, by the way, that John pulls. He makes claims about, there'll be kid claims, which he does that to everybody. But here's the thing, you know, that is actionable as hell. And he has done that so many times. Like, Lynette thinks she wants a fight until she gets it. Then it's not going to be fun. It's not. But I would love to see them be able to put themselves something together, have a bit of fun, do whatever, and get a few dollar dues in the process. You know, it's very doable. Here, let's see. Pull up that Bruce document. Now, this again, this is a pretty fun little dilly here, because you essentially have Jeremy, Randy, they're answering Bruce and saying, "No, you're not supposed to be able to do any of this crap. If you wanted to appeal or anything, well, you had the right to do so, but you were supposed to do that beforehand." Now, if you don't know what's happening here, very briefly, thumbnail case. Thumbnail case. This is Michelle Preston. This is one of her beautiful brain children. You know, her case is there. She and Bruce Manskin get together, and they concoct a way to get paid. Any YouTuber that has put her image on a thumbnail, they think they get paid from it because of commercialization, which is dumb as hell, but you can sue for about anything, right? So Bruce can't practice in Florida, so he enlists this man named Scott Stark. Now, Scott Stark, if you listen to him, I get the very real impression that he had no idea what this case was about. He didn't write anything. He was just a name on a piece of paper that was supposed to get a percentage of a court case. And he was in ill health. He ends up dying for real. And of course, they all try to blame Jeremy Hales. I'd say they end up killing him with all this stupid drama. But anyway, they don't do anything on the case. Nothing. They don't show up for depots. They won't turn over anything. And you have to. At the eve of her having to actually come in and do something, she just, the whole case goes poof. Well, this comes up, of course, as a garbage filing, because obviously you can tell that this is a frivolous lawsuit. I mean, they won't do anything. They just bring it and cause other people to spend money. That is the epitome of a frivolous lawsuit. So the courts are like, yeah, sure is. Well, along the way, you have Bruce, who is not licensed in Florida. He starts writing the courts behind the scenes. And he's not just writing the courts. He's talking about law. He's trying to attack the lawyer that is on the case. He's attacking the other side's client. I mean, he's doing everything a lawyer does, plus things a lawyer shouldn't do. And he gets in trouble for it. He actually has the court not only admonish him for it, but they're like, we're going to refer you over. So he's in a bad place. So what Bruce wants is he, of course, wants this overturned, because potentially he could take a license hit. I mean, depending on what they want to do, they could fine him, suspend his license for time. They could suspend it forever if they want to. It just depends on what they want to do with this. And Bruce must think he's in a really bad position, because he's brought in a couple of lawyers now, but one of them is, again, he's brought in some big name guys that you call in when you're real desperate, which we covered some of that the other day. So he filed which we also covered. And this is the response to said filing, talking about, well, here, let's read it together. So, defendant Jeremy Hale's response in opposition to non-party Bruce Manskin. This is an important feature, by the way, to remember with all of that. He wasn't a party in this case. He had nothing to do with it. So when he talks about this case and he talks about what should have happened, you know, with him and his placement and everything, he wasn't part. Everybody in this fucking cases are crazy, man. They're all crazy. My. Special and limited appearance. Motion to reopen case for limited purpose. Motion to vacate order granting motion to strike unauthorized communication and for sanctions for unauthorized practice of law. Now that is one heck of a title. You have to admit that is a heck of a title for something. I mean, look at this here. Listen, because again, it has it right here. So let's just read. Response in opposition to non-party Bruce Manskin's special and limited appearance, motion to reopen case for limited purpose, motion to vacate order granting motion to strike unauthorized communication, and for sanctions for unauthorized practice of law. That's a lot. that is a mouthful. Lordy. That's a lot to say. So, let's see. Mr. Manskin, an out-of-state attorney who was never a party to this action, never admitted pro hoc vice, and never appeared before this court, now seeks to reopen this closed case and vacate the December 18th, 2025 order entered by this court. Mr. Manskin's motion should be denied in its entirety because it's procedurally barred on multiple independent grounds. So, I mean, the argument there is, again, you think about how crazy this is. He isn't even a party to this case. He inserts himself into it. You have a decision made about it. And he's like, well, even though I'm not a party, I want X, Y, and Z. I mean, it's just insanity. So let's see the multiple independent grounds. First, Florida Rules of Civil Procedure 1.540B does not apply to non-final orders. And the December 18th, 2025 order is non-final because it did not terminate judicial labor in the underlying case. The order addressed only Mr. Manskin's unauthorized practice of law without resolving any claims between the actual parties to Preston and Hale's litigation. Because the order does not constitute an end to judicial labor and expressly reserve jurisdiction to enforce its terms, it is non-final and therefore not subject to relief under said rule. Multiple Florida appellate courts have consistently held that rule applies only to final judgment, decrees, orders, and proceedings. And motions filed under the rule cannot be directed toward non-final orders. So that's pretty cut and dry, first of all. He's saying, hey, you know, nothing has been concluded here. Why? Because, well, we got the bankruptcy going on. So the same thing they tried to weaponize is a problem potentially for Bruce. Isn't that funny? One of Bruce's plans, which again was the bankruptcy decree, one of the things that he himself thought would be good to weaponize, it again doesn't work out for him so well. Fun times, huh? Second, Mr. Manskin lacks standing as a non-party who has never intervened in this action and therefore cannot even invoke that specific rule. Florida law uniformly holds that non-parties are strangers to the record who lack standing to seek relief from orders entered in cases in which they are not parties. Non-parties must intervene to establish standing, and failure to do so bars subsequent attempts to challenge orders. Mr. Manskin had multiple opportunities to establish standing by intervening in this case. Number one, after he exchanged multiple emails with the court. That's true. He could have gotten involved through that. He had his opportunity there. It is interesting. They're like, he isn't even a party. What the hell is he trying to do to set aside something? You have to be a party to this. So he could have been after he wrote the court multiple times. 2, when he received notice of the proceedings at December 17th, 2025 hearing, and or 3, after the order was entered, but he took none of the steps. Instead, he waited approximately 5 months and then filed a motion to vacate, appearing only actually to challenge the order. Isn't that interesting? I mean, as far as timeliness is concerned, you know, Bruce was shaken by this mess, but why didn't he take it seriously from go? That's something I do wonder. You know, courts are not by in and of themselves a timely beast, but they do have time limits on some of the stuff that they do, right? So why didn't he take this seriously? Did he figure, I'll just handle it later? I legitly ask this because I am curious why exactly he did not take this thing seriously at all. I mean, he waited 5 freaking months to try to do something about it. And again, I mean, what did he give up for a minute? Is that what happened? Did he think he boxed himself? It's one or the other. It's either Bruce didn't take it seriously, Bruce being Bruce, which is quite possible. Maybe that is the answer. Or Bruce was like, man, I boxed myself in and now I'm in trouble. I like I said, I don't know the answer to that one either, but it does interest me. I do wonder exactly, what all that means with him. God, Bruce, though, he is really messed up this time. It's so strange to just to watch these folks and to watch what they do. And again, you've got all these people that listen to them like they're, God's gift. How many crazy things have to happen in cases that they were wrong about? I mean, you're talking wrong to the level that they didn't even try to bring a case with the thumbnail case. They didn't. I mean, this on every level went as bad as it can. It didn't go badly. It went as bad as it can. I don't know how any of these people can argue otherwise, because I mean, really, it's there's bad and then there's this. Yeah, I mean, Bruce, Bruce, you really made a mess of this, buddy. So third, Mr. Manskin waived his right to challenge the order by failing to pursue timely interlocutory appeal under Florida Rule of Appellate Procedure. So the December 18th, 2025 order contains an injunction that was immediately appealable. So he could have appealed straight up. So if he really wanted to appeal and he wanted to do this the way it should be done, then. Now, again, I understand for like you or I, if we're out there, defending ourselves, Shield Maiden. Yeah, that's a good statement. Shield Maiden, thanks for the 43 months. Said, by the way, if God really does pay us back, then that explains why LP lives in a dump, scrounging scraps. Yeah, I would say that if you look at certain people's lives and livelihoods, then it always took the statement. Now, it was not intended in exactly this meaning, but I always liked this. There's a German philosopher that noted a statement about things like this, and the way that they utilize this, I think, fits in. They said the gospel of the lowly makes low. You try to take something and you try to even the playing field. And she can't, quote unquote, even the playing field, where it is now, because Well, I mean, look at her. How exactly is she going to quote unquote even it? So it's always a God will do this, God will do that, and they're going to punish you for everything. I hate that. I hate doomsayer preaching like that. Again, I hate it when you don't consider your own failures or inaction. You fixate and focus on everyone else and tell everyone else why they're doomed to fail, or they're gonna go away. And I mean, you're talking about your own family members, by the way. The people you profess that you still love, but God's got it out for them. But it's because there's nothing else that they can turn to. Without that, what else can they threaten somebody with? They're going to threaten them with the lawyer garbage. So they're going to bring another garbage freaking case against people. Again, Preston, I guess she figures she doesn't have anything left to take away. John, hey man, if John brings a garbage case after everything that Lynette Preston has said about him and everything else, and he actually does decide to try to pull one forward, he does have stuff to lose. If he brings one, hell's man, I'm on both sides of that property after all. Well, I didn't really think about that. But anyway, back to this. I'm getting off subject. Sorry. So, Mr. Manskin served with the order an actual notice of it, yet he failed to file a notice of appeal within the required 30-day period. Instead, he waited approximately 5 months before filing an improper motion under Rule 1.540B. This failure to pursue timely interlocutory appeal constitutes waiver and bars his current motion. Florida law does not permit parties to use said rule as a substitute for timely appeal or to circumvent appellate deadlines. Yeah, so instead, he was, let me get this straight, Bruce. You were supposed to appeal within a month. And instead of appealing within said month, you waited 4 additional months. And then said, yeah, this is my great grand plan. I don't know. I've seen some dumb plans, but boy, this one is pretty freaking bad. Oh, Lord. Second, I lost you for a second there, folks. Again, appreciate you folks showing up today. I hope you all had a fabulous holiday, all of you. I know some more people are showing up. Apologies again, last night's video. I keep getting emails about it. Somebody false flagged it. It is back, but what I'll probably do is I will probably take it. I will set it on Locals. Locals, again, you can watch it there. It's free. You can, you can see it there. You don't have to join anything. And there's that should fix the issue, because if I stick it back up there, it'll make a mess. This algorithm is already a mess anyway. It's funny too. These people, they keep dropping out. So you saw. I mentioned this yesterday. You saw Ray announce that he's leaving. He's done. And that might be for the best. They were talking about how, though, Ray really does. They're talking about this last night, too. They were saying, but Ray really does have a stalker. He really does. Anyway, what? Ray? And then they were talking about Just Jay, I suppose. I guess that's who they were calling the stalker. And say because Just Jay laughs at his at his public stuff and makes jokes about how paranoid the dude is. Apparently, Just Jay is now his stalker. Oh, something else, man. Something else. I mean, Ray should go out and enjoy the rest of his life. He strikes me as very lonely these days. A loss will do that to you. But he strikes me as very lonely. So maybe he could go out and have fun in his life. instead of because he doesn't monetize or anything, so he gets no positives out of any of this stuff. He just sits around and fixates thinking people like Just Jay are stalking him. It's very strange. And these people who are supposed to be his friends encourage that. They encourage him into thinking that he is actually being stalked. Isn't that weird? You know, if one of these people were like if Jay was like, "Oh, Tug, I'm being stalked." First of all, I'd laugh at him because I think he was messing with me. You know, but if he actually started thinking that, I'd be like, "Yeah, man, you're an idiot." You know, I mean, these people, are there stalkers involved in it? Sure, but you know, you're probably not being stalked. Now, if he had some evidence of it, that'd be different. But just because somebody reads some of your stuff online, holy crap. Oh, what a bunch of weirdos. Anyway, fourth, reopening this case to consider a motion filed under an inapplicable procedural rule by a non-party who never intervened would undermine finality of the court and is inappropriate. The matter, as Mr. Manskin, is closed. Mr. Manskin has proper remedies that he failed to pursue. Allowing him to, quote-unquote, reopen the matter now would reward procedural default and render appellant deadlines meaningless. For these reasons, the court should deny Mr. Manskin's motion without reaching the merits of his argument. Yeah, they're saying, hey, don't even the argument here is procedurally. I mean, again, you look at 4 reasons. Procedurally, the issues there. Number 1, this doesn't even consider under this rule right here. Why? Because it hasn't been closed out. Therefore, number 2, as a non-party, he doesn't even have the standing to do so. Number 3, timeliness is a real mother of a problem. If he wanted to appeal, and he could have appealed the decision, he should have done that 4 months ago. He waited 5 months. So he had a month and he waited. And he's a lawyer. Again, it's not like you or I doing it and, you know, being stupid. It's somebody that goes online and he's a lawyer. So, again, these are the arguments here. We'll see what the court says. And number 4, reopening this with all of these issues, it actually it undermines everything. So, again, you don't even have to look at their argument, is what the filing is stating. You don't even have to consider what they're stating because everything in it is absolute garbage. All right, let's go. Statement of facts. This action was filed by plaintiff Michelle Preston against defendants Jeremy Hales, George, DUI guy, DJ Radis, and blah, blah case. Bruce Manskin is an attorney licensed to practice law in Connecticut and Massachusetts, but is not licensed to practice law in Florida. He was never a party in this action, was never counsel of record for any party, was never admitted pro hoc vice in this case, and never filed a notice of appearance. See, so he has no standing in the case whatsoever. I think this is good to drill into this, by the way. Again, when you ask, and really, I think the question's there for Bruce too. Why the fuck are you involving yourself in it? It's because he hates these people. He absolutely hates Randy, and he absolutely hates Jeremy. It is very personal for him. I get personal, by the way. I do get it. But you have to be careful about the line. You know, he is a professional in law, should know that there is a line. But then again, I suppose when nobody ever upholds that line, that it's pretty easy to forget about, right? So in October 2025, isn't it crazy, by the way, to look back on and to see how long some of this stuff has been going on? I was going back looking at some of the stuff that had popped up, and I noticed one of the things that happened that we discussed yesterday was from July 2024. I thought, oh my God, isn't that crazy? I mean, this will consume another year. It will for sure. There's no way that this will end this year. There's too much stuff open. And these people, honestly, I don't think they'll let it go. I think they're looking at diminishing returns. I think that's why you see the desperation for them to flip the script. They don't want people talking about what's happened in the past with them. They want to walk away, keep some of that dollary dues, but they're seeing very diminishing returns. But as far as cord and everything else, it's still there. Bankruptcy is still there. It's still going strong. In fact, this month you have, actually next week, what am I saying this month? Next week, you have some depot. We have some stuff coming up in the middle of the month. We have a court hearing at the end of this month. So this month is pretty lively. And it'll just continue like that. I mean, you have things that are paused. To be honest, some of this stuff, they want to delay too. So the very people that complain, they've now tried to, treat this like they're somehow victims of something that keeps going on and on. They are the very people who wanted it delayed. They did not want it to go forward. They bragged about it again. Remember, in Fed 1, for example, when their accomplishment was noting that they managed to delay a case by 5 months. That was considered a win. So just remember that from people that are like, oh, I never wanted any of this. Oh yeah. Like I said, I enjoy this shit show myself. There's nothing wrong with enjoying a shit show. But October 2025, Manskin sends multiple ex parte emails to the court in this case, including emails dated the 6th of October, 7th of October, and the 9th of October. Yes, many emails, many crazy emails, by the way. They are, if you've never read them, you definitely should, okay? If you missed how we got here, you missed out on something amazing. These emails concern matters pending before the court in the underlying action. At that time, Michelle Preston was appearing pro se following the death of her Florida counsel, Scott Stark, in August 2025. That's right. You remember with the Scott Stark stuff too. Again, what craziness. What craziness. So in October 23rd, 2025, Hales, he files a motion to strike unauthorized communication and for sanctions for unauthorized practice of law. Yes, 100% too. And you understand why he did that. Because again, because Bruce just would not stop. He's many things, but he doesn't quit. He doesn't quit. And one of the things that bothers me with that, by the way, is remember, he never joined this case. But with the prior cases, he was on as a quote unquote lawyer for these people. But remember, they fired him. Okay. As far as documentation is concerned, they got rid of him. That is how it reads when you look at the docket. Now, they argue that fact. They say that they didn't, which is very strange, by the way, because if they didn't, then wouldn't that be fraudulent? But I digress. As far as documentation is concerned, it says that they fired him. So you got to remember that. All right, so the 23rd, you have this filed. The motion alleged that Mr. Manskin, as an out-of-state attorney, not licensed in Florida, not admitted pro hoc vice, had sent ex parte emails. Again, ex parte. That's the key in that. He's sending stuff out of school. He knows that he is not supposed to be communicating with ex parte. By the way, remember that means one side only. So what he's doing in this, the reason that is so bad is because that is an attempt to, the way it's perceived anyway, you can argue whether you meant it this way, but the way that it's perceived is it's an attempt to bias the court, because it's only one side. So, he's not arguing anything publicly. Again, he has nothing to do with these people. So, he's not a lawyer or anything. So again, the question is, why is he writing that? And he gets in trouble for it, of course. That is a problem. You cannot do these things. You can't legally. And again, maybe they forget since they have never been taken to task for any of it. I guess it's kind of hard to remember there are rules when nobody enforces them, But I like to, their arguments are always, but Randy, but Jeremy. And it's like, I had to because of X, Y, and Z. Wait, well, really? You had to because they did what exactly? Oh, well, they supposedly they were mean or whatever. I mean, his arguments, he did make legal arguments, like it says, to the court containing legal arguments on behalf of Miss Preston and may have prepared legal documents filed in this matter. She stated that he did. So, again, he went with may have because she's never going to go on record and be like, oh, yeah, 100% he did it. But she did state that. I think that's funny. I think it's funny that she went on record and was like, oh, yeah, he did it. So the motion sought to strike all communications and legal documents attributed to Mr. Manskin, prohibit further communications with the court and parties until he was properly admitted pro hoc vice or associated with Florida counsel, requiring Ms. Preston to identify any non-licensed Florida attorneys who draft paperwork on her behalf and refer the matter to the Florida bar for investigation. Indeed. I wonder this, by the way. I keep wondering about, this isn't the only case stuff like this has appeared in. We've had a little bit of that foraying into to other cases. We've seen Lynette Preston and John Cook, their case. We've seen John Cook filing documents that he says were prepared by Bruce over and over. He's still filing things, those last documents. Look at all those. A bunch of them are Bruce associated, and he's like, yeah. Or he said, Bruce, he filled this out at one time for me. My then lawyer. How'd you think they'd stop? So on October 24th, a notice of evidentiary hearing was filed, setting the motion for a hearing on December 17th, 2025, 1:30 p.m. before the Honorable Robert K. Grabe. Now, Judge Grabe, I think he'd been pretty fair and stuff. They did not like him because he was not, he didn't ignore the stuff that they did over and over again. So they didn't seem to like him. But I thought he was pretty matter of fact and fair. Again, there are rules in a court, and he dropped the hammer on that. Again, that should happen way more often, So, the certificate of service on the notice of evidentiary hearing certified portal service only on, the certified, I'll get it right in a minute. Here, start over. Rewind. That's terrible. Rewind sound. The certificate of service on the notice of evidentiary hearing certified portal service only on Michelle Preston Pro Se at the email address registered with the portal. The notice did not identify Mr. Manskin as a person served, did not list a service address for him, and did not certify any method of service on him. On December 5th, 2025, counsel for defendant Hale sent Manskin a private email attaching the motion and notice of hearing. The email was not portal service, formal email service under Florida Rules of General Practice and Judicial Administration 2.516, a summons, subpoena, or court-issued order to show cause. So he tells them, hey, there is a hearing going on, by the way. So he does actually let him know. What a monster, right? You know what the excuse is to that, by the way? Well, he's such a harasser. I just don't read his emails. That is really what his excuse is to that. For real. Isn't that kind of, I don't know, isn't that kind of nuts? Again, these people are at least entertaining, though. But it is funny. His whole thing is, yeah, I didn't get notice of the hearing, and this guy mailed me, but I'm like, man, it's funny, though, your emails that you're sending into the court, the ones that that are about these folks, you certainly send enough emails to other people to then say that you don't want attention brought to emails. It's just kind of weird, isn't it? Everyone else should read his emails, no matter how they're sent or what they're about. But so the hearing proceeded as scheduled on December 17th and before the court. Mr. Manskin did not appear at the hearing, either personally or through counsel. No transcript or recording was made of the hearing. On December 18th, the court entered an order granting motion to strike unauthorized communications and for sanctions for unauthorized practice of law. The order found that Mr. Manskin is not licensed to practice law in Florida, has not been admitted pro hoc vice in this matter. The order further found that Mr. Manskin engaged in communication with the court and Ms. Preston in this case, including emails for the 6th, the 7th, and the 9th of October, which constitute the unauthorized practice of law a third-degree felony per section 454.23 Florida statutes, referable for prosecution to the Florida Supreme Court. Yes. So again, look at the wording. The wording is careful in all of these matters too. I like how, again, talking about referral, there's a reason that things are listed specifically, because remember his argument was essentially the court can't do anything to me. It has to be referred for X, Y, and Z. Now, the court does have the ability to make decisions about things that happen in its courtroom. As far as other things that are going on with this, though, yes, so you definitely have to have referral, which happens. It does, but it's interesting the way that that Bruce and counsel have portrayed this, like the court has no ability whatsoever to make any decision regarding what happened in their court. Everything would have to be referred out, it's not actually the case that way. But the order, I like some of these on here. The order strikes, so it struck all communications, including emails or any legal documents sent or prepared by Mr. Manskin in the case from the record. Yes. So, and remember, he's mailing legal documents in the case. I mean, it was so flagrant. Like his argument, it's really hard to make the argument that you're not doing these things when, again, the documents themselves that are being issued in the case, they're being mailed around by him. He's making these arguments too. So again, very difficult to make the argument that he's not doing these things. It'll be interesting also with this stuff. One of the things you have to remember with courts is courts do not like to step on other judges. You know, they do not like that. Okay, let's see. So the order, it admonished Mr. Manskin. Not good. It admonished him for engaging in unauthorized practice of law in Florida without proper admission to the Florida bar or pro hoc vice admission in this case. Yes, so they're like, hey, you know what? You're not supposed to do this. I mean, remember, an admonishment, that means to, it's criticizing or warning. It's saying, hey, you know, there's a fault. It needs to be corrected. And it reminds somebody in the definition of this, it reminds somebody of duties in a goodwill, earnest manner. It's not punishing them, though. Admonishment, I see a lot of people when they talk about it, and they talk about the word admonishment like it's punishment. No. The admonishment itself is not. It's a reminder, hey, you need to be doing these things, and you need to be doing, you know, remember, you're a lawyer. Now, again, some of the cases I've read as of late, I don't have a lot of faith in the lawyers out there. I have a lot of anything but faith in many of the lawyers out there. I'm sure you've seen some of the crazy cases that have been coming up as of late. I mean, there's some crazy stuff. There's a case I was talking about yesterday where you have a bunch of lawyers involved in, I'm sure you've seen those videos. I'm not going to talk about the whole case or anything, just to say again, how many scummy lawyers are out there. You know those videos where people cause collisions on purpose for insurance fraud? Well, there was a guy who approached the FBI, I believe it was, to turn witness on a bunch of people who were doing that, and the lawyers that were behind it, and the guy running the scam who was a disbarred attorney. Now, the guy wore a wire. He did all this stuff, and they found out about him, and they ended up offing him. But there were multiple attorneys that were involved in this mess, and I'm not comparing anyone in this to that. I'm just saying, man, there's a reminder these days of how many bad lawyers are out there. You know, when people look at the law, oftentimes they think, hey, you know, there's some mechanism holding people accountable. Is there really? You know, it does a little bit, but you know, it doesn't a lot of. There's a lot that goes on that you have to be like, well, I don't think anybody's actually being held accountable for a lot of that stuff that happens. But the order also enjoined Mr. Manskin from further communications with the court until properly admitted pro hoc vice pursuant to Rule 1.200 of the Florida Rules of General Practice and Judicial Administration, or associated with Florida counsel who actively participates in this matter. Yeah, so can't communicate with the court anymore until either, number one, you manage to get pro hoc vice status, which he knows how to do. He's done it before. Or he gets another lawyer involved, a lawyer that he can work with, you know, which again, he's done that before too. So he knows how to do these things. I mean, he's absolutely been involved in that procedure before. He just, he decided that, no, not this time. So the order also directed Michelle Preston to identify to the court and all parties the names of anyone not licensed to practice law in Florida who gives legal advice to her in matters before the court or drafts paperwork on her behalf, which is then submitted to the court in the future. Finally, the order reserved jurisdiction to enforce its terms. Now, the certificate of service, this was on December 18th, 2025, it shows that copies were furnished via filing with the Florida courts e-filing portal on December 18th, 2025 to Randy Shockett, Michelle Preston, pro se, and Bruce Maskin, Esquire, at his Massachusetts address. The underlying case between the parties remains open as this court, having separately granted defendants' motion for entitlement to sanctions as per Section 57.105 Florida statute, retains jurisdiction to determine the amount of reasonable attorney fees for the sanction for the filing of the frivolous litigation. As Ms. Preston is currently pursuing bankruptcy, this court cannot proceed on a hearing to determine the amount of sanctions until the bankruptcy case is completed. The case is currently stayed as a result. Fun times. Can't get decisions on that. Can't get decisions on more. I'm curious what's going to happen. There's more document, by the way, but I'm curious what's also going to happen with the bankruptcy proceedings and how much money that you're going to have asked for, because they decided they were going to cancel before. I figure ballpark, we're talking what, $2 to $8 grand, somewhere in there. That's just a guess. I have no idea. But again, they keep stacking up money. It's kind of interesting how they keep doing that. So on May 14th, 2026, approximately 5 months after the December 18th, 2025 order was entered, Mr. Manskin files an instant motion appearing usually and solely for the limited purpose of challenging the order. Mr. Manskin seeks to quote-unquote reopen for a limited purpose of vacating the order, or alternatively narrowing it to find all findings of unauthorized practice of law, felony characterization, admonishment, and injunction. Again, what he really wants there is he wants the removal. See, if he can't get it, that really shows you what he's aiming at. He's worried that this is going to cause him a real problem. And it can. And it probably should. Again, he was gunning for Randy so hard. You got to remember all this stuff that these people have been doing, behind the scenes, in front of it, and more. What I'm wondering too, Bruce, have you ever thought that some of these people that you've communicated with over time, they may not turn on you now, but what happens a couple of years from now when they decide that you're more relevant to them if they talk about that? Or maybe you do something, or you don't do anything. Maybe you decide to go and do your own thing. What keeps some of these people in these circles from turning on you and dumping everything that you've stated? Do you really trust these folks to have your back forever? So that's one of the craziest things I think that's come up in this, is when you look at this collection of folks, and you've seen some of the messages that have come up, because people have already, they've taken issue with things that come up. Like for example, Shara, her communications, when she decided to point out everything that happened. I'm sure there are a lot of other ones too. I'm sure there are a lot of other communications. Does Bruce really think these people are going to keep all these secrets forever? That's one of the problems, man, when you get involved with some of these folks. Like some of these folks obviously don't care about the impact. And man, you've linked yourself to them forever, Bruce. Do you think that was it worth it? So argument. The rule 1.540B does not apply because the December 18th, 2025 order is interlocutory and non-final. Now, again, this will define some of this. I actually like having some definition, by the way, on why some of this does not doesn't actually matter in there. How it doesn't. Oh, by the way, somebody wrote and was asking about interlocutory. So pulling up, I'm going to read you the actual definition. Somebody was asking about it. So in a legal context, interlocutory refers to temporary, provisional, or intermediate decision made by a court while a lawsuit is still in progress. It resolves a specific immediate issue to help manage the case, but does not determine the final outcome of the entire dispute. Somebody wrote about that the last time we covered something, because the word was there. So remember, again, when that comes up, it's resolving something in the case, but it's not determining the final outcome of an entire dispute. So it managed a piece of the litigation. So under Florida Rule of Civil Procedure 1.540B, does not authorize Mr. Manskin's motion to vacate because the December 18th, 2025 order is non-final, and because that rule only applies to final judgments, decrees, orders, or proceedings. The order at issue addressed only Mr. Manskin's unauthorized practice of law without resolving any claims between the actual parties to the underlying litigation. Yeah, Preston and Hale's, it hasn't decided anything there because the order does not terminate judicial labor in the case and expressly reserve judgment or jurisdiction, rather, to enforce its terms. It is non-final and therefore not subject to relief under said rule. Said rule's plain language limits the application to final orders. Again, it is only about final orders. I think that's something that, again, Bruce runs into problems. He's not a party to this. So, again, does he even have the right to do certain things? What they're quoting there, does that actually work out either, since, you're only talking about something that is, again, a limited decision as far as its scope. It's not a final decision. And more. I mean, there's so much in here. It's going to be interesting to see how this turns out. So, by its express terms, said rule authorizes relief only from final orders. The rule provides that on motions and on such terms as are just, the court may relieve a party or non-party's legal representative from a final judgment, order, or proceeding for specified reasons, including mistake, newly discovered evidence, fraud, or voidness. Now, Florida appellate courts have consistently held that said rule does not authorize a trial court to grant relief from a non-final order. By its plain text, noting here, by its plain text, this rule only applies to final orders. Quote, on motion and upon such terms as are just, the court may relieve a party or a party's legal representative from a final judgment, decree, order, or proceeding. Notice that, final, big. Also here, the rule does not, however, authorize a trial court to grant relief from a non-final order. And also, that is so because said rule applies only to final judgments, not to interlocutory orders. Since the final judgment is a non-final order, the rule there was not authorized. So the Florida Supreme Court has plainly indicated that said rule is applicable to vacatur of orders that are final. While in 2019, the Florida Supreme Court amended said rule to clarify that motions filed under the rules could be directed toward orders as well as toward judgments and decrees, our Supreme Court plainly indicated that the rule is applicable to seek vacatur of orders that are final. Hence, said rule. Their motion, since this is quoting a court case, seeking to vacate the trial court's non-final February 24th order was not authorized. This limitation reflects the fundamental principle that said rule is designed to preserve the finality of judgments while providing limited ground for relief from final determinations. Multiple Florida appellate courts have dismissed appeals or denied relief when parties sought to invoke said rule against non-final orders. See, that's interesting, I think. Hey, if you look into it, well, many a court has established that, yeah, that ain't going to work for you. When looking at Bruce's arguments there, he really does seem to have a very limited scope, that allows him to argue anything. It seems like a real problem for him. You know what I mean? Like he's kind of boxed into a corner per se. Hey, what's this? 1 second. What? Is there some drama going on today? Wait 1 second. What? I'm trying to find out about something real quick. Give me 1 second. So, said rule authorizes a trial court to grant relief from a final judgment, decree, order, or proceeding, not from a non-final order. Now here, quoted case says, commenting that because underlying order was non-final, quote, a motion for relief pursuant to said rule addressed to it is not a motion seeking relief from a non-final order, decree, or proceeding. Because said rule here, oh my. I'm hearing about something because I'm curious about this. So because said rule applies only to final judgments and not to interlocutory orders, a motion for relief pursuant to the rule addressed to non-final order is not authorized. Quote, the rule does not, however, authorize a trial court to grant relief from a non-final order. And also, again, another case noting that is because said rule applies only to final judgments, not to interlocutory orders. Since the order against Mr. Manskin is a non-final order, said rule, said motion is not authorized. So again, I think that is pretty cut and freaking dry. It's hard. It's really hard not to look at that and be like, wow, that's a problem. That's a big problem. And there are many problems that are going to commence by. So B, Florida's finality test requires unequivocal termination of judicial labor. So to determine whether an order is final under Florida law, courts apply the judicial labor test. Courts generally ask whether the order in question constitutes an end to the judicial labor in the cause, and nothing further remains to be done by the court to effectuate a termination of the cause as between the parties directly affected. That's interesting. Of course, there has to be a definition of what final order means, or what termination, how that is actually entailed. So, again, with this, they look at it, they apply a judicial labor test, and the judicial labor test asks where the end of judicial labor is. So, is there anything remaining that a court needs to do? If there is, then it's not the end. So therefore, no final order. Now, here, we have a case cited from Gainesville. Oh, no, not the Gainesville. Citing the Florida Supreme Court's opinion in an order must have unequivocal language of finality to be final, though no magic words are necessary. Now, Florida courts have consistently found orders to be non-final when they fail to resolve all claims between the parties or where the trial court retains jurisdiction over remaining issues. An order is not a final order or an appealable non-final order where dismissed claims involve the same parties and underlying facts as claims that remain pending. Again, case here, dismissing appeal where the dismissed claim involved the same parties and underlying facts as claims that remain pending. So C, the December 18th, 2025 order is non-final because it did not terminate judicial labor. Yes, again, it doesn't end everything that's going on. There's still crap to be done. The court has to still do things, I guess is the best way to say it. So December 18th, 2025 order fails the finality test because it addressed only Mr. Manskin's unauthorized practice of law without resolving any claims between the actual parties in this litigation. The order struck Mr. Manskin's communications, admonished him, and enjoined future communications, but it did not dispose of all substantive claims or defenses in the underlying case. After entry of the order, in the Preston v. Hale's case continued with judicial labor remaining to resolve the dispute between the actual parties. Indeed, you still have crap to be done. Yes, you cannot have a final order anyway, if so. The order's subject matter confirms its non-final character. The order concerned a collateral procedural issue, whether Mr. Manskin, I didn't even mean to do that. That was an accident. An out-of-state attorney, I don't know why that popped up there, not licensed in Florida and not admitted pro hoc vice, engaged in unauthorized practice of law. The determination did not adjudicate the merits of Hale's 57.105 claims against Preston or resolve any substantive issues between the litigants. The order addressed Mr. Manskin's conduct, not the rights and obligations of the parties to the lawsuit. Moreover, the order expressly reserved jurisdiction to enforce its terms. This reservation of jurisdiction demonstrates that the court contemplated ongoing judicial involvement with respect to the matters addressed in the court. An order that reserves jurisdiction for consideration of remaining issues is non-final and not appealable. So again, they still noted that they reserve jurisdiction. For them to do that, again, you have it terminated because they're saying, hey, there may still be crap to be done, right? And notes here, case holding that trial court order granting entitlement as to fees and costs, but retaining jurisdiction as to the amount to be non-final and non-appealable as it relates to granting of the motion for fees. The retention of jurisdiction to enforce the order's terms indicates that judicial labor with respect to the order's subject matter was not complete. Now, finality is determined as of the date the order is entered, not based on the subsequent events. At the time the December 18th, 2025 order was entered, it did not terminate Preston v. Hale's litigation or resolve all issues between the parties. The order therefore lacked the unequivocal finality required to trigger the application of said rule. Yes, indeed. Yes. Very much. It does not have the ability to do said thing. I like that. It's like it doesn't even have the ability to do this. So, controlling authority establishes that said rule does not apply to non-final orders. Florida appellate courts have consistently held that said rule does not authorize relief from non-final orders. In Columbus Apartments, the court dismissed an appeal for lack of jurisdiction where a party filed said motion directed at a post-judgment foreclosure sale rather than at a final order or proceeding that resulted in a final order. In that, the court emphasized that this rule only allows parties to seek relief from final judgment and orders, and that motions filed under the rule cannot be directed toward non-final orders. So there's a lot it looks like there is a lot of existing case law that states that this may not be something that works out. Again, we will see how court responds to that, but that it just doesn't look very good right off the bat there, does it? So the First District Court of Appeals has likewise held that said rule authorizes a trial court to grant relief from a final judgment, decree, order, or proceedings, not from a non-final order. In said case that we see right there, the court explained that the underlying order was non-final. A motion for relief pursuant to said rule addressed to it was not a motion seeking relief from a final judgment, order, or decree proceeding. The Fifth District Court of Appeals reached the same conclusion in Garcia versus Navy Federal Credit Union, holding that said rule does not authorize a trial court to grant relief from a non-final order. The court emphasized that said rule only applies to final judgments, not interlocutory orders. These these authorities, speak in a minute, these authorities established a rule. I'm reading on something. I'm doing two things at once, and it messed me up for a second there. I'm curious as I got communication stating that that there's something with police calling a certain someone today. That's interesting. I wonder indeed. I'll see if we find out more about that. But yeah, not that I put any faith whatsoever in police, but it would be interesting. I feel like something has been going on lately, something that I'm not seeing. Like there's another piece to things that I'm not seeing, and I'm not talking about all their stupid plans, where they're getting together and trying to file all these garbage filings and stuff. We already know about all that mess. I'm talking about something that is going on that has some actual meaning to it. You know what I'm saying? I feel like I'm missing a piece of something, but we'll see. We will see. So these authorities established a uniform rule of Florida appellant districts. This rule does not provide a mechanism for challenging non-final orders because December 18th, 2025 orders not final. Mr. Manskin's motion seeking relief under that is not authorized by the rule and should be denied. The 2019 amendment to said order did not change the requirements that the order be final. Mr. Manskin, now, I like this because it's going ahead and it's anticipating a potential argument that Bruce may actually try to utilize, stating that, yeah, he may come in and he may try to order or to argue that this does not apply when, but, so he may argue the 2019 amendments has said rule, which clarifies that the rule applies to orders as well as judgments and decrees, authorizes this motion. This argument fails because the amendment did not eliminate the requirement that the order be final. In 2019, the Florida Supreme Court amended said rule to clarify that motions filed under the rule could be directed toward orders as well as toward judgments and decrees. Okay. However, I actually think that's a strategy of ecosystem. Now, I think there's something else going on outside of everything, not just something. I feel like something has worked up some of the old ecosystem in some way. Just some of their actions are kind of, they're not typical, And I'm not talking about a slimy new plan or some garbage like that. I'm talking about how look at the way they definitely seem it doesn't seem like reactions from a place of confidence. I feel like we've gotten a lot of reactions from a state of, I don't know if I want to use fear, but definite worry or concern by certain parties. That's what it feels like anyway. Like there's another piece to something there. And again, I'm not talking about all their stupid little, oh, look what we're planning, all that dumb shit. Who cares about that? They've been doing that they've been doing just stupid things like that for, how long? Years now. They pretty much telegraph that. I just feel like there's another piece to something. I don't know. I'll figure it out. Some pieces too, you'll never have access to ever. You never really know everything, the full scope of what some of these people are doing. Maybe years down the road, again, you might find out when they all eventually turn it. Here's the thing. As much as they want to present a unified front on something, they are all in this for themselves. So when it all falls apart, where it all breaks up, and I'm not saying it falls apart for a specific reason. I'm just saying it'll come apart eventually if parties don't feel like they got whatever they promised or whatever, or it was too high of a cost down the road. Then there might be a problem. I do feel like Lynette Preston was threatened the other night. There were some statements talking about how a certain someone would just walk away from everything. Walk away from it all. Basically, I'm going to take my tent. I'm going to fold it up, and well, you don't get any of that stuff that you were supposed to have had before. It seemed like it's just an implied threat over. I'm not sure if the implication was about the discussion of a channel, like them opening up a channel, or if it was about upcoming testimony. I'm not sure, but it very much felt threat-like. Yeah. So I don't really know what that was there, but it very well, like I said, it seemed like there's been a little work trying to keep Lynette in line. And I'm wondering over time, like Lynette, over time, if she does not get what she wants, if she loses more than she feels she gains, that these people, she will turn on them. I mean, she's done it before. And they'll turn on each other because they turned on her too. So it wasn't exactly a one-sided process, I'll say. But anyway, so the 2019, the Florida Supreme Court amends the rule to clarify that the rule that motions filed under said rule could be directed toward orders as well as towards judgments and decrees. However, the Supreme Court plainly indicated that the rule is applicable to seek vacatur of orders that are final. That amendment addressed the type of final decisions subject to the rule, not the finality requirement itself. So the 3rd District Court of Appeals addressed this precise issue in a specific case here, explaining that while the 2019 amendment clarified that this specific rule applied to orders as well as judgments and decrees, the Supreme Court plainly indicated that the rule is applicable to seek vacatur of orders that are final. Now, the court emphasized that the amendment did not authorize relief from non-final orders. So right here, like I said, I like this addition because this addition seeks to eliminate the argument that they may produce, saying, hey, there was an amendment to this, therefore. Again, you can telegraph certain arguments that will come. And going ahead and eliminating that is actually a smart move. Like I said, I like that. I think that's a good move. Ultimately, we will see everything that goes on with the court. But with courts, too, courts don't really. One of the problems they're going to run into is the judge that made this decision, he retired. So they don't really like to overturn judges that, because overturning a decision is stating that this judge is wrong. I think that I am right in this and this judge is wrong. And that is not something you see a lot of. Usually judges aren't flexing on other judges because that opens them up for it too. It opens up for people to question. You never know what kind of, they could be friends themselves, but even if they're not, you never know what kind of friends that person has either, or again, what kind of problems that could open themselves up for. So we just don't see a lot of that. Like I said, I think Bruce is very desperate in all of this. I think that he has bitten off way more than he really thought he did. And that is his fault. As I've said before, that is 100% Bruce's fault. Nobody else did it to Bruce. He's blamed Randy plenty of times for this. It's so strange how, again, they blame the other parties for all their for their actions. I don't know. I just think that's so bizarre. I was looking at too. This is on a moment. I thought this was funny. I was going through the Hale motion where he's asking for lawyer fees, and he's asking for $50,000 in lawyer fees. Essentially, his lawyer is stating that Hale spent $20,000 for the case, but under under the way that billing should be figured out, etc., that was not enough. Therefore, $50,000. Again, I'm simplifying some of that argument. You should read it all yourself. But it's interesting. I'll be interested to see what happens with all of that too. I'll be interested to see about lawyer fees, if any, how much will be awarded. But that argument, it was just kind of wild. What was wild in it too, there's an email they talk about from Paint Chips in there. And in the Paint Chips email, it's in the billing. Okay. I can't remember. Maybe it was Melissa that pointed this out. I thought this was pretty funny though. I'll mention this while I'm thinking about it. So in the filings, it notes, again, a review and analysis of an email from potential co-defendant and journalist regarding current litigation. All right. So he charges for 0.1 hours, 0.1 for writing an email, or rather analyzing an email. He charged $17.50. All right. Then he wrote in that he prepared an email to his client notifying them to not contact or respond to this said person. So essentially what happened is Paint Chips wrote to Hale and was like, hey, can I get some analysis here? Can I get this or that? And he says, the lawyer says, I read that. And then I wrote an email telling my client not to respond to the press inquiry. So because of that, I charged $35 for that process to read an email and to write, hey, yeah, don't do that. That's interesting, right? That's in part of the billing. I always like going through the billing stuff. Again, with that, we'll see if they get fees. If so, how much? I'm curious about how that will go too. Again, that is a big risk also with lawsuits. That's why when these people keep talking about like their fraudulent garbage lawsuits, That's the thing you remind them of, you know. You you think you don't have anything to lose, but you definitely do, you know. Anyway, let's continue. I just thought that was interesting because that was buried in there. The document itself is about 60 pages long, but you should look through it. Actually, I think we'll look through it one day. We need to. Just to see how that is, how Lodestar works, all of that craziness. Susan Davis, by the way, has put up some really good posts explaining how all of that, how that works, how basically the formula to figure out what is fair or just, how that actually is applied. And then we'll see about arguments again, and we'll see if that happens, because you have one party that, again, out of any of them, unfortunately for the others that thought that they were going to get rich off of all of this, no, they might have had some claim if they would have brought in lawyers for themselves, but like Miltoast was noting, he was like, oh man, it I filed and I was turned down because I asked for costs. It was essentially saying because I had to mail something. Like, these people I tell you, it's just funny, like, watching them and their back and forths about all of that. But anyway, so the 3rd District Court of Appeals addressed the precise issue. Again, it said case, applying orders as well as judgment decrees. Supreme Court plainly indicated that the rule is applicable to seek vacatur of orders that are final. The court emphasized that the amendment does not authorize relief from non-final orders. The interpretation is consistent with the plain language of the amended rule, which continues to require the judgment, decree, order, or proceeding be final. The rule provides that a court may relieve a party from non-final or from a final judgment, order, or proceeding. The word final modifies all categories of determination subject to the rule, including orders. Yeah, indeed. People, they think that, well, you know what's funny? In that, for them to note the cost, they're saying that that something costs $20,000, right? They're actually proving that they filed garbage complaints to the FBI, the IRS, all these other places, the bar and more. Because you think about it, if they're all sitting around and agreeing that 2 motions cost $20,000, but they're writing and saying that Jeremy Hales has somehow, he and his lawyer are committing fraud because they said that costs have reached up to around $500,000. Well, again, if 2 motions cost $20,000, then it would stand to reason that all of this other stuff very well cost you that amount of money. They made absolute fools of themselves doing that. It gave them a headline for a few days. So, you know, as far as that is concerned, perhaps that works out for them. But, you know, again, writing all of that garbage, I swear. So, the order's reservation of judgment or jurisdiction, rather, confirms its non-final character. So the December 18th, 2025 order expressly reserved jurisdiction to enforce its terms. This reservation of jurisdiction is a hallmark of non-finality under Florida law. An order which grants relief but reserves jurisdiction to determine related matters is non-final, non-appealable order which the appellate court lacks jurisdiction to review. The reservation of jurisdiction indicates the courts anticipate a need for further judicial action with respect to the matter addressed in the order. By retaining the authority to enforce the order's terms, the court signaled that judicial labor concerning Mr. Manskin's conduct and compliance with the injunction was not complete. This ongoing judicial involvement is inconsistent with the finality required for Rule 1. The rule, my bad, I was going to read it again, to apply. Now, Florida courts have consistently held that the order reserving jurisdiction to non-final. The reservation of jurisdiction to enforce the December 18th, 2025 order's terms demonstrate that the order did not constitute an end to judicial labor with respect to subject matter. Because December 18th, 2025 order is non-final, it addressed only the collateral procedural matter of Mr. Manskin's unauthorized practice of law without resolving any claims between the actual parties in the litigation, did not terminate judicial labor in the underlying case, and expressly reserved jurisdiction to enforce its terms. Under the plain language of said rule and controlling Florida authority, the rule does not authorize relief from non-final orders. The 2019 amendment to said rule clarified that the rule applies to final orders as well as final judgment and decrees, but does not eliminate the requirement the order be final. Mr. Manskin's motion under said rule is not authorized and must be denied. So part 2, his standing. Now this right here, I thought, was one of the things. Again, it's a real problem. He is not a party in the case. He actually, what's funny is some of his argument attempted to note this at one time too. In fact, I mean, when you look at newer arguments, he is saying, "Hey, I'm not a party to this thing. I'm not part of it. I'm entering this for a limited reason." And it's kind of interesting to see what happens with a non-party in a case like this, and to see what kind of laws are on the books. Because you got to think, like, every law that's out there talking about something like this, it exists because somebody has done something in the past that has caused that rule to be needed. So that's when I always love, people say this about warnings on products, for example. They're like, yeah, remember every warning that you read, that's because an actual person did something stupid that it's pretty much talking about. Well, it's the same thing applies to this. Everything that you read in court filings, somebody has done stupidly or otherwise. So Bruce Manskin lacked standing as a non-party who never intervened. He was never part of the case. So Bruce Manskin lacked standing to file the motion under said rule because he was never a party to the underlying Preston v. Hale's case, never moved to intervene in the proceedings. Florida law is clear that non-parties are strangers to the record who cannot invoke jurisdiction of the court to seek relief from orders entered in a case which they were non-parties. Mr. Manskin's failure to intervene when he had the opportunity to do so bars his current motion to vacate. Yes, that could be a problem. Said rule authorizes relief only for parties. So even if his motion here was authorized under that, this rule expressly limits its application to parties in the underlying proceeding. So the rule provides that the court may relieve a party or party's legal representative from a final order or final judgment, order, or proceeding for specified reasons. This party requirement is not merely procedural but jurisdictional, as it defines who may invoke the court's authority under the rule. Quote, only a party or a party's legal representative may seek relief from a final judgment pursuant to. In order for a non-party to bring said motion, generally the non-party must first intervene and thereby become a party to the suit. So, does he even have standing to invoke said rule that he's trying to defend himself with? You know what's bad is that with or it's kind of funny, really. With every motion that you see like this, you know that Bruce is sitting around and he is stewing over Randy. He is stewing over Hales. He thinks that, in this, even though he was writing the court talking about how Randy's bar licensure should be reviewed. And he's talking about polyflop and all this other dumb shit. I mean, he's writing trying to get somebody disbarred. That's what he's still, he's sitting around with every filing and he is angry. The idea, too, for him to say that Randy sent him an email and he didn't read it, I find that to be laughable. I cannot imagine Bruce not reading something like that. Because, I mean, these people, man, they really want, I mean, as far as reading, like if Bruce writes, hey, I'll read it. It's not like I wouldn't read something coming in, no matter how nasty or ugly. I read the paint chips ones. I read all of those people. So reading them, I read them to entertain myself. These people, though, again, I feel like, again, Bruce has become emotionally invested. That investiture, it's, I think this is, again, just my opinion. I think at one time he was monetarily invested. I think he saw the amount of money and he clipped off just like he's done in other stuff. He decided that he would get himself a little of that contingency, Go after Hales, go after all these other people. In fact, they said that that's what their plans were. They were going to go after one person, after another. And Michelle Preston thought she was going to get millions that way. She thought, it was the payday to end all paydays. She thought that she was going to be rolling in the old cashola. When it doesn't go that way, though, well, you see how that happens. So, even if it was authorized, he can't do it. That's what this is stating right here. The plain language of said rule demonstrates that only parties or their legal representatives may seek relief under the provision. Courts have consistently interpreted this requirement to exclude non-parties from seeking relief under the rule. Quote, as we previously explained, a non-party seeking to participate in a case must generally move to intervene in the proceedings. As a general rule, it is too late to apply for intervention after a final decree has been entered. Mr. Manskin was never a party to Preston v. Hales. The undisputed facts establish that Bruce Manskin was never a party to the underlying case. He was never named as a party, Preston v. Hales. He never counseled WRECKS for any party, never admitted pro hoc vice to practice in the case, never filed a notice of appearance. Most critically, he never moved to intervene in the proceedings. Mr. Manskin did not appear at the December 17, 2025 hearing on the motion to strike. After December 18, 2025 order was entered, Mr. Manskin still did not move to intervene. Instead, approximately 5 months later, May 14th, one day off my birthday. I think that's what that was about, by the way. I think it was about giving me a birthday present, He was like, you know what? I'm going to wait 5 months because Tug will need a birthday present. And I love that guy. I absolutely love that guy. That's what he was thinking. You can feel it, right? You can feel the love. It's amazing. But May 14th, he files his current motion to vacate, appearing only Speechly and solely for the limited purpose. I'm laughing about that. I'm challenging the order. The procedural posture confirms that Mr. Manskin remains a non-party attempting to collaterally attack an order entered in a case which was never a party. So the non-party are strangers to the record who lack standing. Now, Florida law firmly establishes that non-parties lacking standing to appeal or seek relief from orders entered in cases to which they're not parties. The general rule is that a non-party is a stranger to the record and cannot transfer jurisdiction to the appellate court. This principle applies with equal force to motions filed in trial court. Appellate review is limited to the parties in the lower tribunal. A non-party is a stranger to the record who cannot transfer jurisdiction to the appellate court. Non-party lacks standing to appeal an order to the trial court. The same standing requirement applies to motions seeking relief in the trial court, as a non-party cannot evoke the court's jurisdiction to grant relief under said rule when the rule expressly limits relief to parties. Florida courts have consistently dismissed appeals and motions filed by non-parties who failed to intervene in the underlying proceedings. In this case here, for example, the second district dismissed an appeal by a non-party, noting that a non-party is a stranger to the record who cannot transfer jurisdiction to the appellate court. In that case, no way. Yeah, that's the same case, right? It is. That the order denying intervention directed service of subsequent papers on YHT, and that foreclosure judgment listed YHT as the defendant do not support a different result. Similarly, this case here, the third district held that a non-party lacks standing to appeal an order by a trial court. The court in another case here dismissed an appeal when the appellate was never named as a party, nor did he move to intervene in a lower court proceeding, and concluded that he lacked standing. The fourth court reached the same conclusion in said case here, holding that a bank that failed to intervene was not a party to the proceedings below, and therefore also had no standing to appeal the adverse order. Fun times. The first district, it sounds like there is a lot of case law that is that's backing what is being stated here. I think that's kind of, I don't know, it's just kind of interesting considering he had to know. They have to know. But they're like, nope, that's not a big deal. So the first district, or maybe he didn't know. Who knows? He's not a Florida lawyer. So, not like this doesn't exist other places too, I'm sure. But hey, being a lawyer doesn't mean you're a good lawyer. I don't know, or a knowledgeable lawyer, right? The first district similarly held that Hood v. United Planners Bank, that an appellant had no standing to appeal a foreclosure because he was not one of the parties named below and made no effort to intervene. These cases establish a uniform rule across Florida's appellate districts. Non-parties who fail to intervene lack standing and challenge orders entered in cases to which they were not parties. This rule applies with equal force to motions filed in the trial court under said rule. D, Florida law requires non-parties to intervene to establish standing. So Florida law requires a non-party seeking to participate in a case to move to intervene in the proceedings. As one court explained, a non-party seeking to participate in a case must generally move to intervene in the proceeding, and as a general rule, it's too late to apply for intervention after a final decree has been entered. Now, the requirement to intervene is not merely a procedural formality, but a jurisdictional prerequisite to establish standing. There you go. It's not just procedurally dictated. It's a jurisdictional prerequisite to establish standing. Even a or rather, even a party able to intervene as a matter of right, must obtain a court order allowing intervention. That's true. A non-party seeking to participate in a case must generally move to intervene. Yes, so they have to have the court's permission to be jerking around in the case in the first place. So essentially what BBB did is he, I almost said BBD, BBB did is shirk the court's authority. It's like, I'm going to do my thing. That's what it's saying there. I kind of agree. I kind of agree with that. You know, like even if there wasn't a rule, right? Because you think about it, if I'm playing fairly, a court can tell me that I cannot be part of something. But as a non-party seeking to intervene in something without the court being allowed to state something on that, I mean, essentially, they're attempting to circumvent the court and the court's authority by doing so. And a lawyer, again, you or I doing something stupid, well, we could just do something stupid. And that'd be one thing. I could at least understand it more if a non-lawyer does something. But when a lawyer does something crazy, it just, I don't know. It kind of amazes me sometimes. You know what I mean? All right, so let's see. The requirement to intervene is not merely a procedural formality, but again, jurisdictional prerequisite to establish standing. Even a party able to intervene as a matter of right must obtain a court order allowing intervention. A non-party seeking to participate in the order must generally move to intervene in the proceedings. Quote, even a party able to intervene as a matter of right must obtain a court order allowing intervention. Quote, unquestionably, anytime a party seeks to intervene in a cause of action, a two-step process is implicated. First, the court must address whether intervention is proper. Only after a court has determined that intervention is proper does it become necessary to move to the second step, which involves consideration on the merits of the... Yeah, that's true. That is true. So he didn't even let the court go through the idea of saying, hey, is this even proper for him to do? And I mean, he knows, again, he's done this before. Like, I'm not talking about this intervening when he's not supposed to. I'm talking about he knows the procedural requirements. He's been there. So I think that makes it even worse because he knew the correct methodology for doing this, but he didn't want to. He didn't want to become the attorney of record. He didn't want to come in and try to re-involve himself. As he mentioned in the past, which is kind of crazy, by the way, he mentioned that it became too expensive for him. Essentially, it ate up too much of his time, ate up too much of his attention and money, and his practice suffered for it. So he didn't want to do that. But at the same time, he wants to put out enough effort to basically argue or to really go after somebody. You know, I mean, ultimately, I do wonder, is the reason that we see intervention, is that because Michelle Preston, I mean, again, these people promised her quite a bit. We saw the comments about them going after Larry Foreman and going after DJ Radis and et cetera, et cetera. We saw the comments where they were talking about, getting paid because they thought that this was going to be worth a fortune. And turns out it wasn't worth a fortune. It turns out that ultimately Preston, no matter what I think about her, Preston I think she was unduly influenced into doing stupid things. I think that she was given bad advice. You know, when you look at the thumbnail case and you look at the discussions behind the scenes, she was told, hey, you do this, you're going to get paid. You're going to get a substantial payday out of it. You know, she got those dollar due signs up in the eyes. She thought she was going to get really, really rewarded. And then it turns out, yeah, none of that happened at all. You know, instead, she's looking at her case collapsing. She's looking at money coming out of her own pocket. And, you know, you have to ask, when that happened, would she have done this on her own? I wonder that. You know, would she have thought to pursue a case if it would have just been Michelle Preston herself? Or again, is this somebody influencing her decisions? And I think we know the answer to that. Michelle, I don't see her making these decisions on her own, because I think she wanted to get paid. She may have asked questions about, hey, how can I get paid? Can I get paid from X, Y, and Z? But she doesn't have not just the legal know-how, but I hate to call it legal know-how, by the way. Thinking that the thumbnail case was something that was going to get you paid was pretty bad. You know, it was a bad case. It was a very bad case. Well, anyway, let's continue. So the timing of intervention is critical. As a general rule, it is too late to apply for intervention after a final decree has been entered. Manskin, this will be E, has procedural options available but failed to pursue them. So Manskin had multiple opportunities to establish standing by intervening in the proceedings, but he failed to pursue any of them. When he received notice of the proceedings via the December 5th, 2025 email, he should have moved to intervene in the case. He should have appeared at the December 17th hearing to protect any interests he claimed. That's right. That's right. He tried to say, well, I didn't know about it. I didn't look at the email that Randy sent me. Okay. If the court denied his motion to intervene, he could have, Lord, my stomach was, he could have appealed the denial to establish his right to participate. Instead, Mr. Manskin took none of these steps. He did not move to intervene before the hearing. He did not appear at the hearing. He did not move to intervene after the order was entered. He waited approximately 5 months and then filed a motion to vacate, attempting to collaterally attack an order entered in a case to which he was never a party. That sounds insane, doesn't it? First, he attempts to influence a case that he's not a party to, and then he gets called out by the court for it. There is a hearing put on the books for said item, and he decides, nope, don't need to do anything for it. You know, Michelle Preston made a crazy statement one time, by the way, about how she sees court cases. Remember, she is appearing pro se in these things. It also tells you about other people's involvement too. So she's appearing pro se. That means if you're appearing pro se, I imagine you would watch, like if it were you or I, you'd watch the record, right? You'd want to keep up with everything that's going on, because ultimately you are being held liable for anything that goes on. So obviously you want to keep a watch on it. But she stated that she has no idea what's going on in her cases. The way that she gets information about her cases, it's not from her lawyers. This is, to me, this is so crazy. She doesn't find out about things from her lawyers. She doesn't find out about them because of research. She found out about them because of 2L. That's the only way that she stays up to date on any of this stuff whatsoever. Like I said, I think that's crazy. I can't imagine something that potentially impacts my entire life like that and not keeping up with it. But Preston's like, no, I don't. I mean, maybe. I wonder sometimes again. Well, first of all, I think that's a statement that somebody else is making her decisions. Somebody that, again, Bruce, if that's you, buddy, I really hope that's not you, because I'm not saying it is, but man, she will turn on you one day. If she loses everything, I wonder how these people think they're going to keep her, locked down and keep her mouth shut. I wonder what they think they can make work like that. But anyway, Florida law does not permit the procedural end run around the intervention requirement. And a non-party seeking to participate in a case must generally move to intervene in the proceedings. Even a party able to intervene as a matter of right must obtain a court order allowing intervention. Mr. Manskin's failure to seek intervention when he had the opportunity. 1 second. Let me check something real quick. Huh. Oh, man. So somebody got some law enforcement calls. It does sound like that's not that's not good. That's not fun. Fun times, right? Apparently, somebody got some calls while live, from what I'm understanding. That's interesting. So Florida law does not permit this procedural end run, though, which, again, a lawyer should know better. Even a party able to intervene as a matter of right must obtain a court order allowing intervention. Mr. Manskin's failure to seek intervention when he had the opportunity to do so utterly bars his current motion. That means that old Brucey Bruce lacks the standing to file a motion under said rule because he was never a party to Preston v. Hale's, never moved to intervene. Said rule authorizes relief only for parties or their legal representatives. He is neither. His motion to vacate should be denied for lack of standing. Manskin waived his right to challenge the order by failing to pursue interlocutory appeal, even if it did apply to the December 18th, 2025 order, and he had a standing to challenge it, which he does not. He waived his right to challenge the order by failing to pursue the proper remedy, interlocutory appeal under Florida Rule of Appellate Procedure, The order contained an injunction that was immediately appealable. Mr. Manskin was served with the order, had actual notice of it, yet failed to file a notice of appeal within the required 30-day period. Instead, he waited approximately 5 months before filing an improper motion under the rule we've been talking about. This failure to pursue timely interlocutory appeal constitutes waiver and bars his current motion. The December 18th, 2025 order contains an injunction. That date in the order expressly states Mr. Manskin is hereby enjoined from further communications with the court until properly admitted pro hoc vice pursuant to Rule 1.200 under for rules of general practice and judicial administration or associated with Florida counsel who actively participates in the matter. This language unambiguously establishes an injunction. Yes, 100%. The order prohibits Mr. Manskin from engaging in specific conduct, communicating with the court, unless and until he satisfies certain conditions. This is the quintessential function of an injunction, to restrain a party from taking particular actions. Yes, so there indeed was an injunction, and you have a time limit on that. So the Florida Rule of Appellate Procedure 9.130A3 provides the immediate appeal of injunction orders. So, said rule authorizes appeal of certain non-final orders to the District Court of Appeals. Specifically, said order permits immediately appeal of, quote, non-final orders that grant, continue, modify, deny, or dissolve injunctions, or refuse to modify or dissolve injunctions. The Florida Constitution grants district courts of appeal the authority to review Non-final orders, to the extent provided by rules adopted by the Supreme Court, said rule provides the authority for orders involving injunctions. December 18th, 2025 order falls squarely within this category. By enjoining Mr. Manskin from communicating with the court, the order granted an injunction. This made the order immediately appealable under said rule, regardless of whether it was a final order. An interlocutory appeal was made. It was Mr. Manskin's proper remedy to challenge the injunction. Notice of appeal must be filed within 30 days. So, pursuant to said rule there, the jurisdiction of the appellant court must be invoked by filing a notice of appeal within 30 days of rendition of the order to be reviewed. Again, I do not understand, Bruce, why you made it 5 months. You knew this was happening, and yet you chose to wait 5 months. Did you think that legally, like that would give you some kind of deniability? Oh, sorry, I just noticed this just now. It just slipped into my desk somehow, you know. How dare they? How dare they not tell me about this decision in a case that I'm not a party of but intervened into? I mean, what's funny is with all of his denials and stuff too, he definitely knew enough about this case. You know, he can't, I'm sure he'll plead ignorance, which he did. You know, he pled, he tried to play it. I didn't know, you know, nobody told me. And yet, when you look at everything, you know, and the way that it came up, isn't it interesting that, again, Bruce, he already had involved himself so much in this case. It's so strange for him to be like, but I didn't know. You know, well, that didn't stop you before not being served with something from knowing about everything involved in the case and filing orders and everything else, you know? So why did it stop you now? What's the difference? Oh, because you want to appeal something for yourself in that. So you somehow you don't know anymore. I think that's interesting, you know. Bruce suddenly he has no idea that something's going on. These people crack me up with some of their stuff they do. I had no idea this was going on. How could I? Well, how did you know about everything else that was going on, Bruce? How did you know to file motions regarding some of the decisions? Because you were keeping up with the case, man. I mean, come on, dude. I get, again, it's not beneficial to say that you knew about it. But man, what a ridiculous argument, considering, you know, he keeps up with every freaking filing, everything. He used to be very vocal about stuff, you know, but he's still around. We found that out because he popped up in one of Jeremy Hale's chats. He just right now has been having a few problems, we'll say. So he gets a 30-day deadline. That 30-day deadline is mandatory and jurisdictional. Time limit begins to run from the date of the order. So he had 30 days from December 18th. He failed to file a timely notice of appeal. The undisputed fact established Mr. Manskin failed to pursue timely interlocutory appeal. The order was entered December 18th. The order was served on Mr. Manskin via the e-filing portal December 18th. Mr. Manskin did not file a notice of appeal within 30 days of the order. He didn't file an appeal or reconsideration of the trial court on May 14th, approximately 5 months after the order. Mr. Manskin filed the motion to vacate under said rule. The 30-day period for filing a notice of appeal expired in mid-January 2026. His motion, nearly 4 months after the deadline expired, cannot resurrect his lost appellate rights. Motion for reconsideration of non-final orders do not toll the appeal period. Unlike authorized and timely motions directed to final order, motions for reconsiderations or rehearing of non-final orders are unauthorized and therefore do not toll the 30-day limit for filing a notice of appeal. So that's interesting as well. You know, even if he had filed a motion for reconsideration then, which he did not, such a motion would not have extended his time to appeal. The 30-day deadline would have continued to run, and his failure to file a notice of appeal with the time period would still constitute waiver. The fact that Mr. Manskin filed no motion for reconsideration and has simply allowed the appeal period to expire makes his procedural default even more egregious. Yeah, that's true. Call him out. That's exactly what he's getting. He's getting a heavy call out with this as well. It's like, man, are you kidding me, Bruce? What in the world are you trying to pull here? Because this is absolutely newts. So F, failure to pursue timely interlocutory appeal constitutes waiver. Mr. Manskin's failure to pursue timely interlocutory appeal constitutes waiver of his rights to challenge the December 18th, 2025 order. He had actual notice of the order as it was served on him by the e-filing portal on the date it was entered. He had clear and available remedy. Filing a notice of appeal within 30 days of, he chose not to pursue that remedy. He failed to act within the prescribed time period and bars his current motion. The policy underlying appellant deadlines is to promote finality and to prevent parties from indefinitely challenging orders. That's true too. You know, what's to keep a party from coming back 5 years later and being like, you know what? I think now is a good time. I do think that's a good argument. Because, I mean, ultimately, how long do you allow this to go on? Do you allow him to do it? Okay, 4 months. What about 6? What about 8? What about a year? How long do you allow somebody to sit around and to play this weird game? You know? Like I said, I like the argument with that. Because you can tell... You got to remember the courts don't. We know Mr. Manskin too. You know, we actually know Brucey Bruce. But even if we didn't, we're like the courts, and you know we don't have any idea. We just have to go off of paper filings. You have to ask again. How long is too long? So the policy underlying its provoked finality, when a party has actual notice of an order and a clear remedy available, but fails to pursue that remedy within the time prescribed by the rules, the party waives the right to challenge the order. Mr. Manskin cannot now, 5 months later, attempt to obtain through a Rule 1.540B motion the relief he failed to seek through timely appeal. G, 5-month delay demonstrates lack of diligence. Its 5-month delay between the entry of the order and the filing of the motion further demonstrates that his motion should be denied. The order was entered on December 18th, 2025. He files May 14th. This substantial delay is inconsistent with any claim of urgency or prejudice. That's true too. Even under said rule, which permits challenges to void orders, all motions seeking relief must be filed within a reasonable time after entry of a challenged final order. Simply filing a motion to vacate pursuant to said within 1 year of a final judgment does not eliminate a litigant's responsibility to file the motion to the attention of the court within a reasonable time. Here, Mr. Manskin's 5-month delay is particularly unreasonable given that he had an immediate relief available through interlocutory appeal. That's right. If the order truly caused him the harm he now claims, he should have acted promptly. See, that is the thing too. If all of this is so bad like he claimed, why was there no urgency? Like, why did he not go? I mean, again, what's the point of him delaying to this? I mean, legally, what is the point in this delay? I actually think it's a good point. I would actually like an answer. I wish Bruce would answer that. You know, like, why did you wait 5 months, Bruce? For real? Like, outside of the court, I would like an answer just outside of the court itself. You know, I'd like him to be able to throw down some kind of answer for that and to tell us. You know what I mean? That way, you and I, we could know, because again, Bruce, he knew about it. He's claiming all of this damage too, and it is an important thing. Did he just not take it seriously? Like, what does that all mean, Bruce? I'm very confused by the whole thing. Like, I don't get why you would wait. I'm not a genius lawyer like Bruce there, you know. So maybe that's why I don't get it. But if it were my licensure and my reputation and all this, and I thought, hey, all of this stuff is it's important, I need to get it done, why wouldn't I do something and do it in a timely fashion? I don't know. But anyway, it's so bizarre. So his failure to do so, I mean, again, it demonstrates a lack of diligence. So reopening the order is inappropriate. Mr. Manskin seeks to reopen the challenge, to challenge an order he failed to timely appeal. This court should decline to do so. He had proper remedy and interlocutory appeal under said rule and failed to pursue, allowing him to reopen the challenge. To challenge an order he failed to timely appeal would reward procedural default. The Florida appellant rules establish clear procedures and deadlines for challenging orders. When a party has actual notice of an order, has an available remedy, and fails to pursue that remedy within prescribed time, the party cannot seek to reopen the case through improper procedural vehicle. To hold otherwise would render the appellant deadlines meaningless and encourage party to ignore procedural requirements. Yeah, exactly. You know, if one party can do this, why have rules whatsoever? Why ever have them at all? Like that really brings that up. And moreover, Mr. Manskin's 5-month delay is seeking relief demonstrates a reopening to challenge an order he failed to timely appeal is not warranted. If the order truly caused him immediate and irreparable harm, see, that's what he's saying. It caused him immediate harm. If it causes you immediate harm, why do you then delay for 5 months? I think, like I said, I think that's a good question. And it's a good question beyond the court. I mean, it's just a question I would love to actually hear an answer to. Like, how, if you think it's such a bad thing and it did so much harm to you, then why would you allow said harm to just sit? Why wouldn't you do something about it before you ran out of time, you know? I would want to myself, you know. I wouldn't want to risk everything by letting something just sit around on the books and continue. Like, again, if it's causing that much harm, which he's saying it did, it harms reputation, it harms everything. It's irreparable. It's immediate and irreparable. This failure to seek timely interlocutory appeal constitutes waiver and bars this current motion. The court should deny Mr. Manskin's motion and decline to reopen the challenge an order he failed to timely appeal. So for the foregoing reasons, here's our breakdown. We are at the end of the document. It did take us a while to get here, but we are here. Defendant Hales respectfully requests that the court enter an order, number 1, denying non-party Bruce Manskin's special and limited appearance. Motion to reopen case for limited purpose, blah, 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 blah. So to deny it. That's what they're saying. Hey, you know, straight up, we're asking you, number 1, to deny the thing. I mean, which makes sense. You would want that denied. Number 2, decline to reopen to challenge an order he failed to timely. So they're like, hey, you know, he shouldn't get another bite at this because he he didn't bother to even to file in a timely fashion. I mean, it is wild. It is kind of wild to see. I think you and I are going to have an interesting show when that pops up. I think it'll be interesting again to see what a judge has to say about it. Because a judge, ultimately the argument may be sound, but the only person to say that it's truly a sound argument is a judge. You or I looking at it, or a good filing, but I still don't see why anyone would argue against, a judge would argue against another judge. That just doesn't happen, man. That's really where you run into a problem, where Bruce runs into a problem, because you typically do not have judges arguing with other judges about their orders. So affirming the December 18th, 2025 order, finding that Mr. Manskin's motion is procedurally barred because A, the Florida Rule of Civil Procedure here does not apply to the non-final December 18th, 2025 order. He lacks standing. He waived his right to challenge by failing to pursue a timely interlocutory appeal, and reopening is inappropriate. And then anything else. So I think that it makes sense. It definitely makes sense. The question becomes what the court allows. And the court, again, if you have deadlines, why have them if you're going to allow people just to continue to do X, Y, or Z, right? I think that makes sense. All right, so let's go through some super chats. I think we have an interesting follow-up. Give me 1 minute. I'm looking at something. Somebody sent me something. I was trying to see what it was. That's the same here. Okay, so Risa, thank you for the 2 there. Again, hope you all had a great holiday. Did. I hope you had a fabulous one as well. Hope it was fun. Simply Me Connie, thanks for the 10. Taking heat off of them and Felicia, trying to put it on Ashley. Oh, yeah. They have tried. They have tried very, very hard to cause Ashley problems. But here's the thing. I think that ultimately Ashley and her husband, you know what people like that do? You know what they cause ultimately? They cause one of 2 things. They either break you down and they destroy you, which obviously if they were going to have done that, they would have already done it. Or they bring people closer. And I think when you see, again, when you saw not just Ashley, but you see family standing up, not just her husband, you see her sister standing up and more. I think that speaks volumes. It also speaks volumes every time something like that comes up. You notice that you have it like a weird insult off of it. People aren't allowed to have their own opinions. They're somehow being manipulated by someone out there, because when you look at like when she talks to Samantha, for example, she's always blaming Ashley for the decision of somebody not believing. Not that somebody would just look at everything that happened and choose not to believe Lynette. Oh, no. That's because somebody else has poisoned their mind. There always has to be another villain. It can't be Lynette Preston and, herself in that type of villainy. God. What's amazing too is, again, she brings up the idea that she was given an email. So the other thing I think I didn't really note, but I thought really backed up what was being said as well. She admitted that law enforcement, there was a contact. So she talks about email from law enforcement. I thought that was amazing. I like too that she grapples onto this idea that everybody's paid to go after her and just sometimes after a while people probably get sick of you and they talk about what's happening. They don't like being attacked. Most people would move on and do something else, but and I'm not talking about random people out there, by the way. I'm talking about people in your own life. That's the craziest part. Maybe my family is weird in this, but we don't typically attack one another, you know? That's not a norm for us. Like, I get some people do that, but that's not our norm. It's just strange to me to think of attacking my family. You know, I appreciate my family. Can you imagine like having somebody that pretends to be mother? I don't get this either. So they also, they made a big deal out of daughter versus stepdaughter. They made a big deal out of it, which I thought was ugly by itself. But on top of it, I don't understand how you can have a person that keeps claiming, adoption and this and that, but doesn't believe that daughter versus stepdaughter, that would be the same thing. Like, again, I was a step kid, and there is no way in hell that my stepfather would have ever been like, you know what, you're just my step kid. Not a good one, So I don't get this. I don't get how anybody could make that, but especially when you talk about like adoption and stuff. If you've got an adopted kid, how can you not? Anyway, I don't know. Something to bark about. Thank you for the 5 giftos. I hope, by the way, something to bark about. You build up something amazing. You have you have all the tools. You have the ability to do so. I hope that you make something fabulous out of your channel. Again, just do live streams. Do what you enjoy too. A lot of people, and be yourself. People forget that. They try to be something online. They try to put on airs. And so just be yourself. Have fun. Have a good time. If you do that, I think you'll do great. And I think you've been doing great already. So just keep doing it. But I do I appreciate you too. I think you've built up something that, like I said, it can have a lot of fun with. Thank you. Connie, thanks for the 2. Tug is Tulsa King. Tulsa King. God, wouldn't that be funny? Oh, I can't even imagine the Tulsa King. I haven't watched that show in a minute, by the way. I did like that show, though. That is a good show. I've enjoyed it quite a bit. It's funny. Skipper, what's up, Skipper? How you doing, my friend? Thanks for the 14 months. I hope you're doing amazing, by the way. Appreciate you. Something to bark about. Thanks for the 10 there. Happy birthday, America. Looking good for 250. That's right. That is right. Doug, I'm 30 from the 1K. Oh, yeah. You're there now. You are there now. So much love to you. Cynic, thanks for the 2. Need prayers and the ER again. Oh, man. Look, everybody keep Cynic and Chief in your prayers there. I absolutely love Cynic. Cynic is a great person that's been around forever here and it needs support there. And man, remember, you always have support here, brother. You know, for real. You're much appreciated. You get to where you know people. You know, they've been around so much, so often. So I do appreciate you. Man, get well. You know, you're not allowed to be like this. 2012, thanks for the 2. Does LMNOP lie through tooth? She asked for it. I think it would be lying around your tooth, wouldn't it? I mean, wouldn't that be the way, you know, because you couldn't lie through it. So I think it would be lie around your tooth. But I don't, I wonder with LMNOP. It's funny. She says this, that, and the other. She told us as soon as she hit 1,000 subscribers, she would have that live stream. Remember? As soon as I hit 1,000. So she's had it for days now. Yet another lie, right? Yet another lie. Ashley, hey, thank you for the 5. Annabelle is the daughter I miscarried. Oh, that's awful. She asked me if I could if she could use that name as HG's middle name to honor Belle, and told her absolutely not. That's awful for her to pull. That's awful. That's yet another nasty thing. I'm sorry to hear that too. I mean, I can't imagine as a mother what miscarriage is like, but we experienced that. And it was very trying. As a father, it was. Again, I can't speak. I can speak on what I saw, and it was awful. But, I mean, just as emotionally as a father, you know, we went to, between the oldest and the youngest, my ex got pregnant, and she was, you know, there was, with what we thought would be our second kid. And she, we went in and it was doing okay at first, you know, had taken everything, but in the next, I can't remember if it was 2 appointments or 3, just so long ago. And it's, you know, something you don't really want to hold on to there. But from there, you know, with the ultrasound, you just tell that nothing, there was nothing there. And then in the aftermath, oh, just so awful for a woman, you know, all the stuff that goes on with that. So for somebody to bring that up and to try to weaponize it, you know, she gets a lot of grace because people are like, oh, she's old, doesn't remember. I think she remembers a lot. I think she just does stuff like that to be nasty, you know? But I'm sorry to hear that, man. I really am. I'm sorry you know, the one great thing that you have in your life is you can appreciate the, you know, a lot of people when they have folks around and everything, they don't like family. Some people don't appreciate the idea of family, but now where you've had this kind of crazy, it makes you appreciate the people that actually do love and care about you and your family. So at least there's that, but it's awful that a person would use that against you. Again, I think she does stuff like that intentionally. I think she brings it up. She not only tries to warp it, but she knows that if you have to speak about it, that it's painful. And I think that's again, it's 100% by design. You have to be a terrible person to do this stuff, though. So many of these people are terrible people. They don't care who they hurt. Again, John last night made it real clear what he thinks he's doing. He thought, again, the brother of the husband, most people don't know husband's name, so that's why I keep saying husband, of Ashley's husband, he thought that he had Down syndrome. Now, again, he went through and corrected and said he had a brain tumor, and that was what everything had gone on between that. But John thought he was attacking somebody with Down syndrome, and he was totally happy to do that. He was totally happy. That just shows you the kind of people you're dealing with. And Michelle is like, well, I don't control him. Now, she controls him when it's convenient. When she wants him to stop something, she absolutely has control. But when she doesn't, it just shows you she wants this to continue too. That letter, I don't know. I really don't like these people, and I hate it for all of y'all. God, that's awful, man. I really am sorry to hear that. Jack's mom, thank you for the gifted membership there. Thank you, Jack's mom. I appreciate you. It's good to see you as always, too. Blue Eyes, what's a Blue Eyes? Thank you for the 10 gifted memberships there. Hey, Blue Eyes, do me a favor. Drop me, if you can, and don't mind to, drop me an email. I'm curious. Are you a U.S. Are you in the U.S.? If you're comfortable with any of that, just drop me an email. I want to ask you something. Okay. And thank you. Thank you for 10 gifted memberships too. Appreciate you. Shieldmate, thank you for the 43 months. If God really does pay us back, that explains why LP lives in a dump scrounging for scraps. Yep. It's indeed. Remember when they brought up, remember when all these people were attacking people because they thought folks didn't have money. It was an attack versus they went after all these antis went after people because they thought that Jeremy Hale's audience, some of the people out there were pores, and it was so bizarre to look at because they try to conflate the type of stuff that they do as being poor, maybe poor in spirit, but it's just so bizarre to see how, they've tried to excuse so much of this bad behavior, like being, like not having money, quote unquote, being poor. That's the way they put it. Being poor gave you, it makes you an awful acting human being. And I don't want, I'm telling you, the more I've dealt with these folks, the worse and worse they are. It just amazes me. But yeah, I agree. Max, thank you for the super chat there. Appreciate you, Max. Bonnie, thanks for the 20 months there. Hope everybody had a great 4th. Oh, you too, man. I hope you really had a great one as well. I had a good one. Again, the kids were funny. They they blew up a lot of stuff. One of the boxes for the firework caught on fire outside. You know how they do sometimes. And the little one, I'm like, man, I got to watch you because, man, she loves fire. Like, oh no, but she loves watching fire. She does. She likes it. I'm like, man, little arsonist, she likes to set things up. I mean, I can't say anything. I used to like to set stuff on fire, but she's so funny to watch about it. She loves watching things catch on fire. Hey, what's up, Jaguar? I missed myself. Oh no! Did I? I'm so sorry. I'm so sorry. You know what? I'm going to give you something with that. First of all, I have to give you 2-step process with that. You remember the old birthday? We'll do that first. Happy birthday from all of us to you. Maybe these short arms will make that mistake. Not seem so unreasonable. Yeah. Ooh. I swear. That sucks. No, love to you, my friend. And
Happy birthday from both of us to you. Happy birthday. May all your dreams come true. Happy birthday.
Happy birthday.
We love to have you here. Happy birthday. Here's to another year.
Man, if you did note that yesterday, though, I apologize. I do miss some every now and then, but I hate it when I miss anything, but I definitely hate it when I miss something important like that. That's definitely important. Yeah. What in the world? What? Huh. Man, there is so much crazy. I'm reading something else here. Good Lord. Yeah, I'm reading some, I'm trying to figure out what this is too. There's so much crazy going on. Oh, Lord, oh, Lord. All right. Cynic, thanks for the 2. Need surgery? Oh, man. Stone removal surgery tonight. Oh, dude, for sure then. Hey, people, for real. It'll probably give you some relief, though, buddy. You know, with all that, the way that's been going. That's what my dad used to have to do. I'll keep you in prayers for sure. You know? Give me 1 second. Yeah.
Yo, can you mute that?
Huh?
Can you mute that?
I read the thing. I'll have to respond to it in a minute. I got a call in a few minutes anyway. Okay.
I gotta ask you something.
Oh, okay. I'm gonna mute for 1 second. All right, sorry about that. But yeah, Cynic, man, I'll definitely keep you in prayers, man. But with that happened with my dad a few times. When they would get really bad, he'd have to have surgery. He had to have surgery multiple times. So the only reason I mentioned that is because that was the only thing that really ended up granting him relief. You know, but again, everybody keeps Cynic in your prayers there for sure. And like I said, man, love to you, brother. You know, Anthony, the warrior, thanks for the 9 months. Grats to something to bark about. 1K subs, indeed. You know, something to bark about. I love that too, because with something to bark about, just run a something to bark about. They run a nice thing. You know, something that a lot of people online, they're always saying, man, I wish I had something that wasn't drama or anything crazy. Well, there you go, man. There you go. That's exactly what that is. It's something that's just, you know, it's normal. It's not full of stupid or drama. It's just something you can laugh at, have fun with. And there's not enough of that out there. So if people want, again, you want to enjoy some, you want to see fun with animals, you can tune into something to bark about. You try to get, you know, for me, like, again, I love crazy and chaos, and I could deal with it every single day. And some people can too. But for those out there that, you know, there are always people that are talking about, man, I wish there was something less crazy online. Well, there are alternatives. Again, like something to bark about, for example. And I'm glad they're on the road. Monetization there, everything. It's great. Katie Rose, thanks for the 5 months. Sending hugs from hot Kansas. Hope the girls had a fun 4th. They did. And yeah, it has been hot too. It has been ungodly, you know. So I hope everybody is staying cool. When we went out the other day, the little one rarely complains about being hot, like really hot, you know. And I took her to the store with me the other day, and we were getting in the car, and it was just like oppressively hot. And she was complaining about it. She was like, I can't stand this heat, Dad. It's terrible. I was like, I hear you, kiddo. She's like, you got to get that air cranked up. I'm dying. That was so funny. But, you know, it's hot then. Pandora, thanks. 12 months. Thank you there. Happy Sunday. Bobby's plane just landed. I haven't seen him in 2 weeks. Oh, that's awesome. That is awesome. It always feels good. You know, that whole idea of distance makes the heart grow fonder. It really does. That doesn't, you know, a lot of people misread that too and read it as not caring or loving, you know, and only distance bring. No, distance, I think, makes you appreciate what you have sometimes. You know, you see it, and it's great to be reunified. So that's awesome. Stacey, I think it's 20 months. Yours is today, too. Well, you know what that means, don't you?
Happy birthday from both of us to you. Happy birthday. May all your dreams come true. Happy birthday. We love to have you here. Happy birthday. Here's to another year.
Many more. Heck yeah. Oh, Sassy. Yeah. Actually, one of the mods sent it. Let me give me a second. I saw that. One of the mods sent it over, and I forgot all about it. Give me a second. Yeah, here it is. So, Sassy will send video for the girls. Nashville fireworks. Happy 4th. Today is the 26th wedding anniversary. It seemed to be hubby went to rehab. Let me see if I can pull all the rest of that. It cuts part of it off. Yeah, actually, the mods, they're really good about trying to know stuff like that. And let me give Rhea Raya some love for that. So Rhea Raya actually noted that at the end of the show, like, oh, one came in right at the end. So I'd totally forgotten about that until just now. Let me see if I can find it. Just give me 1 second. Here's the third. Oh man, I don't see it. Can you mail me about that? I'm sorry. It's just not, for some reason, it is not popping up on my my list there. I wonder if that's you know, it credits super chats even if a video gets knocked down, but I'm wondering if it took it off my list. Huh. I don't know. But can you mail me and let me know what was cut off on that? Because I can't see the bottom part of it. But I appreciate you there. Oh, hey, Blue Eyes. No, you, everything's good. I just, I was just wondering. I was just asking for something. You're great though. You are absolutely wonderful. I wanted to ask you about something real fast. So I'm Melanie question if you're okay with that. So let me know the rest of that though. I can't. It cut off part of it. And I can't see the very bottom. E Poindexter, thanks for the 15 months. Just got back from being pyro crew for our city's firework display. It's more fun spending other people's money to blow stuff up. That's true. That is true. Yeah, going out and buying just fireworks again. Every year, I try to buy a minimal amount of fireworks. You know, the girls, the oldest wouldn't even care, but the you know, as much. But the youngest, she's at that age where she's like, "Oh, I want fireworks. You know, I want to see it and everything else." And then in the South, especially, it's such a big deal. But you know, it's such a big deal to have your own. Is what I mean. You know, so getting fireworks though, they had the little kids backpack. It's like $25 for that. 25 freaking dollars just for that. Oh man, that's crazy. And then you know, any other fireworks. It was like Roman candles are almost a buck something a piece. It's crazy around this area. I think blowing stuff up would be cheaper. ePoindexter, thanks for the 5 gifted memberships there. Thank you very much, ePoindexter. I appreciate you too. It is so good to see you, as always. 1 minute. Interesting. I just got sent some interesting stuff. My. Emma, thanks for the 20 there. I haven't been around much lately. I went and fell in love. Hey, that is you know what? We all have our lives and go live, you know. This is I look at it this way. I'll watch like a TV show here and there, right? But I don't watch that much TV or anything. I keep up with crazy stuff online. This has become my TV. But, you know, YouTube and anything else, never letting it in the way of what you're doing there. But yeah, when I let's see, preparing to move in together. That's awesome. So life is busy. I hope you and the girls are doing great. I'm hoping to get him into all this craziness once he's here. I think he'd have fun with it. You know, like more people as they see it, I think they would enjoy just the insanity of it all. Again, I know it's not fun for the people involved, but for the people out here watching, it's crazy. That's when I say fun, you know, fun may not even be the right word, but yeah, it's just the insanity to it. I like it because it's unpredictable. These people are so nuts. And anytime they start, they never seem to do anything for a good reason, you know? They do things for crazy reasons. They never, I've never had one of them surprise me in a positive way. I guess is the way to put that. You know what I mean? Like some people, you're like, man, that person there, you know, they really surprised me by how good of a person they are, or by this or by that. I've never felt that way with these folks. I've never been like, man, you know, I am really surprised by just how good of a person that is. I'd love to be surprised like that. You know, I would. I'd love to be surprised by that, but I doubt we'll ever see that. But yeah, I hear you. Hey, congrats. For real. Congrats to you. It's rare when we find it also it feels good in those moments, you know, to have that thing, that driver. And to find finding love is a good feeling. I was noting, so I had another person ask me out not too long ago. I had someone ask me out, and then I've gotten a few here and there, but in the community, I had somebody ask, man, there is this weird thing that I get. Look, I'm going to show you this real quick, guys. Because this is so bizarre, and I don't get it. Give me 1 second. Oh man, tonight's live stream over on Hales looks like it might be good. You know, I mean, they're good live streams anyway, but I'm curious about Oh, it might be fun to watch. So check this out, though. There's something fraudulent as hell that goes on. See this. I've got to set up anytime I do a live stream, right? I have to, when I redirect, I have to pick up like a what the hell's, for example. But check this out. So when I go to redirect, this is what I see, anything with what the hell's attached to it. So obviously my stream has got a tag for what the hell's. It's ongoing. So I can redirect to it. And then there's Jeremy's over there. What is that thing in the middle? I get a notice for that off and on, like I can redirect to it. And that's obviously not the correct thing. So what the heck is that? I mean, isn't that weird? You know, I mean, that's very bizarre. It's like a fake what the hell's, you know? And Blue Eyes, thanks for the 2. Whereas, oh, your email come in. You are not in trouble, by the way, in any way, shape, or form. No, you are very appreciated. That's why I asked, you know? One second. I'll note what the reason I'm asking, though. But anyway. Today, I think this week is going to get really crazy. I think there's going to be a lot of interesting stuff that is going to pop off this week. I think you all are going to be in for a wild one. But Hales comes up. He's talking about he's actually talking about the depot stuff that's upcoming. How do I put this? I enjoy his content on like his normal content, but man, he has got a good knack for laughing at stupid people. I don't think he gives himself enough credit for that. I think he's got a good talent for that too. I know he that's not the main focus of what he does, but I like it when he laughs at these stupid people. You know, it also reminds them they're not winning. They're not winning anything. And I like that too. So I do enjoy those types of streams when he pulls them out. But anyway, all right. Well, I'm going to redirect you guys over in just Emma, what's up? Thanks for the 10. I had given up on finding love. Then literally a few days later, I met him. It was instant for both of us. Soulmates really do exist. Just hoping I don't ruin it with my anxieties. Hey, you know what? With a person, they will accept you as you, with everything that comes with you, because, you know, in the moment, it's easier, you know, to be like, but they've got to know you later on with all of it. You know, they will love everything about you, and they probably do. You know, if they enjoy you, they will enjoy everything about you. But you know, you are who you are. Never worry about being you. If it's meant to be that way, it will work out. And again, it sounds like it's moving along well. I was mentioning, so yeah, I had this person ask me out, and I keep running into that wall of, man, I kind of I don't know the right way to say this. I kind of enjoy the freedom of, you know, I don't have anybody telling me anything to do anymore. So, yeah, I've got the girls, obviously. I do for them. But outside of that, it's been kind of interesting and nice not to have anybody else like giving me any feedback on how to live my life, you know? Like it's kind of an interesting change. Like after years of that, and again, there's nothing wrong with that when I say that. I don't mean that negatively about anybody either. But it just, I'm like, man, I can do anything, you know, barring again, I got girls to take care of. I got to take care of them. But outside of that, I can do whatever. You know, if I want to I want to sit up all night long watching freaking TV, or I want to play a video game right now and there's nobody to complain. Or if I want to eat bologna sandwiches, which I like. If I want to eat bologna and cheese and egg sandwiches for my dinner tonight, nobody will complain. And I like that. I like it quite a bit. But on the other side, man, when you want somebody there, it feels good. It feels good to be wanted, for sure. So you enjoy that. You enjoy that feeling, and don't worry about ruining anything. Again, one of the things that sometimes will cause us problems is worrying about like some of the stupid. So just don't worry at all, you know. But anyway, I'm going to redirect. I appreciate you folks. And I think Megan's back tomorrow. I believe so. If not, well, we'll figure it out. All right. See you folks.